You're hearing three cases, 2023 CT 392AO, 2023 CT 393AO, and 2023 394AO. And it's one count of attached license plate not assigned. Driving with driver's license suspended or revoked with knowledge. One count of no motor vehicle registration. I do find probable cause as to each offense. I'll appoint the Office of the Public Defender to represent you.
There's no offer at this time as Mr. Bowie's on probation.
Right. So he is entitled to a bond, correct?
Yes, Judge.
You know what he's on probation for? I'm just asking the attorneys. I don't want you to say anything that may, but I'm just asking them, okay?
I believe it's a cocaine case, Your Honor.
All right. All right. So I do find there's probable causes to each offense on the driving while license suspended or revoked with knowledge. Court will note you have 7 prior failure to appears. I'm going to set bond in that case at $1,500. On the attached tag not assigned, I'm going to set bond at $100 and no motor vehicle registration at $100, okay? So you do have bonds on that case. That's it. You have bonds on your cases, okay? All right, good luck, sir.
With the probation, I think I looked and it said I had a 5-day hold.
Yeah.
I basically had to wait to see what's going on with that.
Probation's got to see if they're going to violate you, and then you'll have to come back to first appearance again, but that's for another day, all right?
Thank you very much,
Yep,
sir.
good luck.
Have a nice day.
You too. 100 on the tag and registration each, 100, and then 1,500 on the Willis. All right, sir, your name?
It's Cameron Armand Jackson.
All right, Mr. Jackson, you're here in 2023 CF 737AO, one count of criminal mischief, one count of resisting an officer without violence. I reviewed the arrest affidavit. I do determine there's probable cause as to each offense. I'll appoint the Office of the Public Defender to represent you. We'll set bond at count 1 at $1,000, count 2 at $100. And do not return to the scene where this was alleged to have occurred, okay? That's as a condition of your bond, all right? Good luck. All right, sir, your name?
Nelson Taylor.
All right, Mr. Taylor, you're here in 2023 CF 724AO and 2023 CF 196AO. I'm going to appoint the Office of the Public Defender to represent you in each of those cases. Both those cases, you were arrested pursuant to a warrant. Probable cause determination has been previously determined by the judge who signed the warrant. In 2023 CF 724AO, there were 4 counts. 2 counts of burglary to an unoccupied structure, 1 count petty theft, and 1 count of criminal mischief. I'm going to stay the bonds in the warrant at $2,500 to each burglary of an unoccupied structure count, $500 on the petty theft, $500 on the criminal mischief. With regards to 2023 CF 196AO, stay the bond at, what's it?
I just have the one case.
Oh, 196 I think was previously set
Right.
at $1,500. That's right.
Conditions on the warrant, no contact with the victims and
And then the conditions on the warrant, the no contact with any of the alleged victims and then no return. Is there no weapons on there too? No. No contact and no return, okay? All right.
You got an affidavit for this?
What's that?
Affidavit?
An affidavit?
Yeah.
I don't have one. I don't have one printed, Your Honor, but the attorney can get it to you. If
Yeah,
you
the
call the
attorney,
number.
you have an attorney appointed to represent you. You should be able to access that through your attorney, okay? All right, good luck. All right, sir, your name?
Jaquan Vega.
All right, Mr. Vega, you're here in 2023 CF 705AO. There's a warrant signed for your arrest with 2 counts. 1 count sale delivery of cocaine within 1,000 feet of a child care facility. 1 count of sale delivery of cocaine. The bonds on the warrant were $15,000 on count 1, $5,000 on count 2. We're going to stay the bonds in that case at $15,000 in count 1 and $5,000 on count 2. Are there any other conditions on that one? I don't think. All right, with the conditions of your bond that you do not return to the scene where this was alleged to have occurred. You also possess and consume no alcohol or illegal drugs, all right? All right, good luck.
What's the old bond?
I got. So I got 2 new bonds.
Your Honor, from what I saw, do you only have
There were bonds all right, so there's also
previously
20,
set,
I was
right?
already bonded out.
Okay.
Other cases.
you have other cases. You have 3 cases, all have the same counts. So they're alleged to have occurred on different dates, different offenses. So we were only here on 2023 CF 705AO today, all right? All right, sir, your name?
Clyde Webb.
All right, Mr. Webb, you're here on 2023 CF 750AO. It's one count of possession of MDMA. Reviewed the arrest affidavit, do determine there is probable cause. I'll appoint the Office of the Public Defender to represent you, and I'll set bond at $1,000, okay? All right. Good luck. All right, ma'am, your name?
Connolly,
First name?
Olivia,
All right, this is 2022 MM 8586AO. You're here today for an arraignment on one count of trespass in an occupied structure. That's a first-degree misdemeanor. You're already represented by the Office of the Public Defender. Counsel, what are we doing with this one?
The offer from the state was indication of guilt, credit time served, no return to 2155 West Colonial Drive. There's also a cost of investigation in the amount of $84.16 to the Orlando Police Department. Ms. Connolly would like to accept and enter a plea of no contest.
All right,
May I approach, Your Honor?
you bet. All right, thank you. All right, Ms. Conley, you heard what your attorney had to say. Is that your understanding what's happening here today?
yes, sir. I also like a copy of,
Get
the
it once
amount.
you get it.
It'll be in your paperwork.
Give it to you.
Okay, yes.
All right. You understand that by resolving your case here today, there's not going to be a trial and that you're waiving the constitutional rights that are listed at the top of the plea form?
Understood.
All right. You understand that if you're not a U.S. citizen to plead, this offense will subject you to deportation?
Understood.
And do you understand if you've ever been convicted of a sexually motivated or sexually violent offense, a plea to this offense could subject you to involuntary civil commitment?
Understood.
All right. Are you on probation for any other offense?
No, sir.
All right. Anyone threaten you or coerce you to enter this plea?
No, sir.
All right. You under the influence of any drugs, alcohol, or medication that's affecting your ability to understand what's happening here today? All right. We'll accept the no contest plea. We'll adjudicate you guilty, sentence you to 28 days in the Orange County Jail with credit for the 28 that you've already served. So you will be released as it relates to this charge today, okay? Also order that you do not return to 2155 West Colonial Drive. Also have to assess court costs, plus cost of investigation of $84.16 to the Orlando Police Department. I'll give you 1 year from the date of your release to take care of the financial obligations or to be on a payment plan making regular payments with the clerk's office, okay? All right, you have 30 days to appeal the judgment and sentence. Have a step outside and they'll give you your paperwork, okay? All right, sir, your name?
Johnny Dassey the third.
All right, Mr. Dassey, you're here in 2022 MM 8661AO. You're here for an arraignment on one count of petty theft of $100 or more. That's a first-degree misdemeanor. You're represented by the Office of the Public Defender. Counsel, what are we doing with this one?
We're going to enter a plea of not guilty, Your Honor.
All right. Enter not guilty plea. Your next court date will be,
Division 62, February 9th at 1:30 in courtroom 12C.
all right. Good luck to you, sir. All right, sir, your name?
DeQuan Elliott.
All right, Mr. Elliott, you're here in 2023 MM 285AO. You're here for an arraignment. It's one count of resisting an officer without violence. It's a first-degree misdemeanor. You're represented by the Office of the Public Defender. Counsel, what are we doing with this one?
Okay. There was an offer to resolve, Your Honor, with an adjudication of guilt. Credit time served. There's also a cost of investigation of $178.26 to the Orlando Police Department. Mr. Elliott would like to accept and enter a plea of no contest. I just need a moment because I wasn't.
Probation also.
He's on probation. He just said he wants to resolve it anyway, so he'll deal with it in Seminole County,
All right,
which is why I didn't fill the form out.
all right. All right, you understand, but by resolving your case here today, by entering a plea, you're probably going to be, there's a very good chance they're going to use this to violate your probation in Seminole County?
Correct, Your Honor.
All right, you still want to resolve your case here today?
Yes, sir.
You had the opportunity to discuss that with your attorney?
Yes, sir.
All right.
We're going to enter a plea of no contest, Your Honor.
All right. So you've heard what your attorney had to say. That's your understanding what's happening here today?
I sure do, sir.
All right. you understand that by resolving your case here today, there's not going to be a trial on the resisting officer without violence offense, and that you're waiving the constitutional rights that are listed on that plea form you just signed? You got to answer out loud, yes or no.
Correct, Your Honor.
Yeah, I see you shake your head, but the court reporter is making a record, so I just got to ask that you answer out loud, so thank you. All right. I know we talked about it, I'm going to ask you again. You understand that because you're on probation, a plea to this criminal offense will probably be used to violate that probation?
Yes, Judge.
All right, and you still want to resolve your case here today?
Yes.
All right. Anyone threaten you or coerce you to enter this plea?
No.
All right, you under the influence of any drugs, alcohol, or medication that's affecting your ability to understand what's happening here today?
Not at all.
All right. You understand that if you are not a U.S. citizen, a plea to this offense will subject you to deportation?
Yes.
And do you understand that if you've ever been convicted of a sexually motivated or sexually violent offense, a plea to this offense could subject you to involuntary civil commitment?
Yes.
All right. All right, we'll accept the no contest plea. We'll adjudicate you guilty, sentence you to 39 days in the Orange County Jail with credit for 39 days' time served. We'll also have to assess court costs and the cost of investigation of, it's $178.26. Yeah, $178.26 to Orlando Police Department. I'll give you 1 year from the date of your release from custody to take care of the financial obligations in this case, okay?
Yes, sir.
All right, you have 30 days to appeal the judgment and sentence. Have a step outside, and you'll be released as it relates to this charge today, but you'll probably be held on the VOP, okay?
All right, not a problem.
All
Thank
right,
you.
good luck.
Have a great day.
You too.
You're welcome. I'm so sick of seeing you. I see you every time.
All right, sir, your name?
Oh,
Danny Garcia, sir.
All right, Mr. Garcia, you're here in 2021 MM6982AO.
same.
You're here for an arraignment on trespass on property other than a structure or conveyance. Was there an offer to resolve this case?
Not at this time.
Okay.
I would ask that you appoint, Your Honor.
I'm going to. I'm going to appoint the Office of the Public Defender to represent you, so you now have an attorney appointed to represent you.
We'll enter.
Yeah, go ahead.
We'll enter a plea of not guilty.
All right, we'll enter not guilty plea. Your next court date will be,
Division 83, February 13th at 8:30 in courtroom 6C.
all right, February 13th at 8:30 is your next court date.
Your Honor, what case were we addressing for Mr. Garcia?
He's got a what?
What case are we addressing?
2021 MM6982.
Okay, all right, because he was time served on his other cases. He's going to be sent over to Osceola County now to serve those charges.
Okay.
I just want to make, okay.
We're not being held on the summons.
Oh, he's not being held on this.
No, it's a summons case.
No, it's
Okay.
something else.
So you're
That
still
was my
going to
question,
Osceola.
sir.
Yeah, he was times, yeah, he's,
So.
All right, so we'll enter not guilty plea. You're not being held on this, so you're gonna go back, you're gonna be transported to Osceola County, all right?
Thank you, sir.
Yes.
How long do you have to wait, sir? I've been waiting 10 days.
If I told you, I'd be guessing, so good luck.
maybe
Thank you.
tomorrow.
I might go tomorrow.
Have a nice day.
All right. 2022 MO1389AO. Your name, ma'am?
LaMargaret Hudson White, January 29, 1989.
This is an MO. Should it be an MO or is it it's a petty theft? So it's,
City case, I believe, Your Honor.
I didn't know the city did petty thefts, but not surprised they do, but I just don't know if I've seen one. All right, 2022 MO1389AO. Office of the Public Defender has been previously appointed to represent you. What are we doing with this one?
The offer from the city was an adjudication of guilt, credit time served. There's a $10 filing fee and $223 in court costs. And Ms. Hudson White would like to accept and enter a plea of no contest.
All right, you heard what your attorney had to say. Is that your understanding of what's happening here today, ma'am?
Yes, Your Honor.
All right. I was handed a plea form. Did you sign the bottom of the plea form?
Yes, I did.
All right, you understand that by resolving your case here today, there's not going to be a trial and that you're waiving the constitutional rights that are listed at the top of the plea form?
Yes, Your Honor.
All right, you on probation for any other offense?
No, sir.
All right. You understand if you're not a U.S. citizen, a plea to this offense will subject you to deportation?
Yes, Your Honor.
And do you understand that if you've ever been convicted of a sexually motivated or sexually violent offense, a plea to this offense could subject you to involuntary civil commitment?
I understand, Your Honor.
You under the influence of any drugs, alcohol, or medication that's affecting your ability to understand what's happening here today?
No, Your Honor.
All right, anyone threaten you or coerce you to enter this plea?
No, Your Honor.
All right, well, accept the no contest plea. We'll adjudicate you guilty and sentence you to 31 days in the Orange County Jail with credit for 31 days that you've already served, so you'll be released as it relates to this charge today, okay?
Thank you so
There's
much, Your
also,
Honor.
yep, there's also $233 in court costs plus a $10 filing fee.
Can I have time to pay that with my city clerk of course if I
Yeah,
get on the
I'm
payment
gonna give you,
plan?
how much time do you need to pay?
I need
Two hundred
about
and
a
fifty
year
bucks.
because I just paid 400 yesterday with a bond for trespassing.
All right, I'll give you a year from the date of your release to take care of the financial obligations, or be on a payment plan with the clerk making regular payments, okay?
Yes, sir.
All right, you have 30 days to appeal the judgment and sentence. Good luck.
Thank you so much, Your Honor. I appreciate your help.
No, thank you. Good luck
Thank
to
you
you.
to the city of Orlando.
Okay. All right, sir, your name?
Marcellus Johnson.
All right, Mr. Johnson. 1 second. This is case 2023 MM278AO. The docket says you have Charles Taylor as your attorney.
Yes, sir.
All right, you're here for an arraignment today. It's 1 count of trespass on property other than structure or conveyance. All right, he was the attorney, it was a conflict counsel, right? Okay. All right, so you're here on trespass on property other than structure or conveyance. That's a first-degree misdemeanor. Was there an offer to resolve this case?
No, Your Honor.
All right. There's no offer to resolve your case, so we're going to enter a not guilty plea on your behalf. You're going to get a court date some date in the future, which will be,
It's gonna be Division 61. It's gonna be February 3rd at 10:30 in courtroom 7C.
all right, your next court date's February 3rd at 10:30, okay? All right, good luck. All right, 2022 MM8502AO. Sir, your name?
Kevin Tubbs.
All right, Mr. Tubbs, you're here for an arraignment on 1 count of petty theft or $100 or more. That's a first-degree misdemeanor. The Office of the Public Defender has been previously appointed to represent you. Counsel, what are we doing with that one?
The offer from the state is a withhold of adjudication, credit time served, no return to 718 McGuire Boulevard. There's also a cost of investigation of $255.25 to the Orlando Police Department. And Mr. Tubbs would like to accept and enter a plea of no contest, Your Honor.
All right, is that Target?
Yes.
I could go back.
All right, Mr. Tubbs, you heard what your attorney had to say. Is that your understanding what's happening here today?
Yes,
All right. You understand that by resolving your case here today, there's not going to be a trial, and you're waiving the constitutional rights that are listed at the top of the plea form?
yes, sir.
All right. You under the influence of any drugs, alcohol, or medication that's affecting your ability to understand what's happening here today?
Just my hearing a lither bit.
Okay. Well, if ever you can't hear me or anything, just stop me and I'll repeat it, and I can slow down for you too, okay?
Okay,
Other than your hearing, you under the influence of any drugs, alcohol, or medication that's affecting your ability to understand what's happening here today?
no, sir.
All right. Has anyone threatened you or coerced you to enter this plea?
No, sir.
You understand that if you're not a U.S. citizen, a plea to this offense will subject you to deportation?
Yes, sir.
And do you understand that if you've ever been convicted of a sexually violent or sexually motivated offense, a plea to this offense could subject you to involuntary civil commitment?
Yes, sir.
All right. Are you on probation for any other offense?
No, sir.
All right. Well, accept the no contest plea. We'll withhold adjudication, sentence you to 31 days in the Orange County Jail with credit for 31 days time served. You'll be released as it relates to this charge today. You also order you do not return to the target at 718 McGuire Boulevard. Also have to assess court costs and cost of investigation of $255.25 to Orlando Police Department. I'll give you,
Do you pay that to the police department? Do
you're-
you pay that to the police department?
the instructions to pay will be in your paperwork. You pay through the clerk of the courts, okay?
Thank you, sir.
I'm going to give you 1 year from the date of your release to take care of the financial obligations as it relates to this case, or be on a payment plan making regular payments, okay?
Okay, thank
All
you,
right,
sir.
you have 30 days to appeal the judgment and sentence. Have a step outside, and they'll get you a process out of here, okay?
Mr. Tubbs.
All right, sir, your name?
Adams, from Adams.
All right, this is 2023 MM377AO. It's 1 count of trespass on property after warning. I've reviewed the arrest affidavit. I do find there is probable cause. Was there an offer to resolve this case?
Yes, Your Honor. The offer is an adjudication of guilt, credit time served, and no return to 601 East Rawlings Street, absent a medical emergency. And Mr. Adams would like to accept and enter a plea of no contest.
All right. He still has a trespass order from there, right?
Yes.
All right. I understand we've worked in absent a medical emergency, but that subjects us to, I just don't want to do a no contact order from the hospital. I understand it's absent, I know it's an emergency room. He's already got an active trespass from there, so I think that mitigates the need for a, if he goes back and it's not a viable reason, he'd be arrested, right? Okay, all right. All right, so I'm gonna scratch the do not return.
Okay.
All right. I'll admonish you not to return, but I'm not gonna order it because I don't want, it's a hospital, okay? All right, sir, you heard what your attorney had to say. Is that your understanding of what's happening here today?
Sir.
All right. You had a chance to go over this plea form that you signed at the bottom? All right. You understand that by resolving your case here today, there's not going to be a trial and you're waiving the constitutional rights that are listed at the top of the plea form? All right. Are you on probation for any other offense? All right. Do you understand that if you've ever been convicted of a sexually motivated or sexually violent offense, a plea to this offense could subject you to involuntary civil commitment? You understand that if you're not a U.S. citizen, a plea to this offense will subject you to deportation? I think I already asked you, but I'm going to ask you again. Are you on probation for any other offense? All right. All right. So, you're already trespassed from the hospital there. The court's not going to order you to not go back there, but that trespass warning's still in effect. So if you go back there, you're going to be arrested pursuant to that trespass warning, okay? You understand that? All right. So it's in your best interest, unless you need to go to the hospital, and it better be a good reason, not to go back to the hospital, you're going to get arrested again. You understand that? All right. All right, we'll accept the no contest plea. We'll adjudicate you guilty. Sentence you to, 2 days? 2 days in the Orange County Jail with credit for the 2 that you've already served, so you'll be released as it relates to this charge today. There's also court costs. I'll give you 1 year from the date of your release to take care of the court costs or be on a payment plan making regular payments, okay? All right, you have 30 days to appeal the judgment and sentence. Have a step outside and they'll process you out of here, okay? All right, sir, your name?
Alan Frazier.
First name?
Alan
Last name?
Frazier.
Where's the Ahmad come from?
That's my middle name.
Okay. All right, just making sure we're all on the same page. All right. This is 2023 MM394AO. It's 1 count of disorderly intoxication. I've reviewed the arrest affidavit. I do find there is probable cause. I'll appoint the Office of the Public Defender to represent you. What are we doing with this case?
You'll sign here. I was trying to change it. The offer from the state is going to be a withhold of adjudication, credit time served, and I believe no return to the border bar.
Is that in OIA, though? Is it
That's
in?
in the airport.
Right. So he can go to the airport, just not that bar, right?
That's what,
Okay. I don't want to no return somebody to the airport either with a, if they've got to
sorry.
travel somewhere. Especially for, never mind. All right, sir, I was handed a plea form. Did you sign the bottom of the plea form? All right, you understand that by resolving your case here today, there's not going to be a trial and that you're waiving the rights that are listed at the top of the plea form? You got to answer out loud, yes or no. I see you shaking your head, but the court reporter is making a record.
Yes.
That's all right. Anyone threaten you or coerce you to enter this plea? All right. You under the influence of any drugs, alcohol, or medication that's affecting your ability to understand what's happening here today? All right. You on probation for any other offense? You understand that if you're not a U.S. citizen, a plea to a criminal offense will subject you to deportation?
Yes.
Do you understand that if you've ever been convicted of a sexually motivated or sexually violent offense, a plea to this offense could subject you to involuntary civil commitment? All right. All right, we'll accept the no contest plea. We'll withhold adjudication. Sentence you to 2 days in the Orange County Jail with credit for 2 days you've already served. Also, order that you do not return to the Border Bar located in Orlando International Airport, okay? All right, with regards to the court, I also have to assess court costs. I'll give you 1 year from the date of your release to take care of the court costs. If you want to pay them before then, you can, but you have a year to take care of those, or else there'll be a suspension on your driver's license, all right?
Okay.
You have 30 days to appeal the judgment and sentence. You have to step outside, they'll process you out, okay?
Have a good one.
You too. All right, sir, your name?
Donald Hope.
All right, Mr. Holt, this is case 2023 MM378AO. It's one count of loitering and prowling. I've reviewed the arrest affidavit, determined there is probable cause. I'll appoint the Office of the Public Defender to represent you.
Your Honor, there was an offer actually to resolve
Okay,
with an adjudication of guilt, 5 days in the Orange County Jail with credit for 2, is that right? Okay. And no return to 2353 Lake Deborah Drive. And Mr. Holt would like to accept and enter a plea of no contest.
all right. Mr. Holt, you heard what your attorney had to say. Is that your understanding of what's happening here today?
Yes, sir.
All right, I'm saying that a plea form has your signature down at the bottom. Did you have the opportunity to go over the plea form?
Yes, I did.
All right. You understand that by resolving your case here today, you're waiving your right to go to trial on the charge, and that you're also waiving the constitutional rights that are listed at the top of the plea form?
Yes, sir.
All right. And are you on probation for any other offense?
No.
You understand if you're not a U.S. citizen, a plea to this offense will subject you to deportation?
Yes.
And do you understand if you've ever been convicted of a sexually motivated or sexually violent offense, a plea to this offense could subject you to involuntary civil commitment?
Yes, I understand.
All right. You under the influence of any drugs, alcohol, or medication that's affecting your ability to understand what's happening here today?
Yes, sir.
All right, anyone threaten you or coerce you to enter this plea?
No, sir.
All right, we'll accept the no contest plea. We'll adjudicate you guilty, sentence you to 5 days in the Orange County Jail with credit for the 2 days that you've already served. Also order that you do not return to 2353 Lake Deborah Drive in Orlando. Okay? I also have to assess court costs. I'll give you 1 year from the date of your release to take care of the court costs, the financial obligations. And you have 30 days to appeal the judgment and sentence, all right?
What day is it?
Wednesday.
Your Honor, Mushin is mental health.
All right.
Can we reset for tomorrow, Your Honor? I didn't see any competency concerns that she has an offer to resolve. She may not have been seen by mental health yet.
All right. You want me to appoint your office to represent her? Or just reset it for tomorrow?
Oh, okay. I will waive, Your Honor,
All
actually.
right, I'll appoint the Office of the Public Defender to represent Ms. Mushin. Waive her appearance. I've reviewed the arrest affidavit. Do determine there's probable cause. I'll set bond at $250 with a no return.
Thank you.
All right, sir, your name?
I'm Rudolph Dawson.
All right, Mr. Tossi, you're here in 2023 MM392AO. It's one count of petty theft, one count of criminal mischief. I reviewed the arrest affidavit. Do determine there's probable cause. Set bond on count 1 at $500 and count 2 at $100. Also order that you have no contact with any of the alleged victims. I'll appoint the Office of the Public Defender to represent you in that case. You're also out on bond on 2022 CF 11570AO.
State would request no action, Your Honor.
No action? All right, based on the state's request, the court's going to take no action on that. So you have bonds on your new case. You're still ROR on the possession of cocaine, okay? All right. All right, ma'am, your name?
Rena Washington.
All right, Ms. Washington. You're here on 2023 MM393AO. One count of exposure to sexual organs, first offense. I'm appointing the Office of the Public Defender to represent you. I've reviewed the arrest affidavit. I do determine there's probable cause. Set bond in this case at $500. Also, as a condition of your bond, Do you have any conditions you'd request, State?
Your Honor, State, we just asked for no return to that mapping zone.
All right, that's what the court was gonna do. So, gonna order that you do not return to the mapping zone. That'll be in your paper as a condition of your bond, okay? All right, good luck to you, ma'am.
You gotta pay them. You pay it, I'm saying. No, you gotta pay it first.
All right, good luck. All right, sir, your name? Sir, your name? All right, Mr. Green, you're here in 2022 MM 5285AO. It's one count, it's a warrant for your arrest for a failure to appear. The bond in that warrant was $2,000. I'm gonna stay the bond at $2,000. I'll appoint the Office of the Public Defender to represent you.
Your Honor, actually, the,
I'm sorry,
They
I
all-
can't hear and listen.
the offer from the state is an adjudication of guilt, credit time served, and no return to 5734 South Orange Blossom Trail. Mr. Green would like to accept and enter a plea of no contest.
All right, Mr. Green, did you hear what your attorney had to say?
Yes, yes.
All right, is that your understanding what's happening here today?
No, I don't know. So I get to go home today?
You'll be entering a plea to a criminal offense, waiving your right to go to trial, your rights associated with going to trial, and you'd be sentenced to, how many days does he have in?
Right, yeah, that's what I'm saying, but this credit time served means I get to go home today, right? Credit time served, that's what that means, right?
Yes,
Okay, that's what I was asking the judge.
you'll sign here.
All right, well, I was trying to explain, it's a little more than that. It's not like you just get to go home. You get to go home because you're being sentenced to 2 days in jail with credit for the 2 days that you've already served. But by entering that plea, you're also entering a plea to a criminal offense and waiving your right to go to trial. I want to make sure you understand all that. You understand all that?
Yes, sir.
All right.
I believe we were appointed, Your Honor, in this case.
What's that?
I believe we were appointed in this case.
Okay.
Trying to make sure.
I probably, if there was a. All right. So I was handed a plea form. It's got your name down at the bottom of it. Did you sign this plea form?
Yes, sir.
All right. Did you have a chance to read and go over the plea form?
I believe so, yes, sir.
All right. You understand that by resolving your case here today, there's not going to be a trial and you're waiving the constitutional rights that are listed on the top of the plea form?
Yes, sir.
Are you on probation for anything else?
No, sir.
You understand if you're not a U.S. citizen, a plea to this offense will subject you to deportation?
Yes, sir.
Do you understand if you've ever been convicted of a sexually motivated or sexually violent offense, a plea to this offense could subject you to involuntary civil commitment? Do you understand that?
Yes, sir.
All right. Anyone threaten you or coerce you to enter this plea?
No, sir.
Yeah, are you under the influence of any drugs, alcohol, or medication that's affecting your ability to understand what's happening here today?
No, sir.
All right. All right, well, accept the no contest plea, sentence you to 2 days in the Orange County Jail with credit for 2 days that you've already served. So you'll be released as it relates to this charge today. Also order that you do not return to 5734 South Orange Blossom Trail, okay? Also have to assess court costs. I'll give you 1 year from the date of your release to take care of the financial obligations or to be on a payment plan making regular payments. You also have 30 days to appeal the judgment and sentence, okay?
Okay, so I will be able to go to work tomorrow. Thank you, sir.
Yeah, good luck. All right, ma'am, your name?
Jolanda Patrick.
All right, Ms. Patrick, you're here in 2022 MM 5214AO. This one is a warrant for your arrest for failure to appear. The bond in that warrant was $400. Was there an offer to resolve this case?
Not at this time.
All right, so I'm going to stay the bond in that warrant at $400, okay?
Okay.
All right, good luck.
That's it?
That's it.
The bond can't be lower?
It's only $400 for a failure to appear. You're not entitled, you're lucky it's not zero, so. Guys, show up to court.
How are you?
All right, ma'am, your name? Your name?
My name is Linda Shakur, which is on my license. However, at the very top, the defendant had me under another name, but the narrative at the bottom has me with my original name.
Do you know who Linda Talon is?
That is an assumed name that I used in the past, but that is not my legal name right now.
Okay.
So there's two different names, and I just wanted to call that to your attention.
That's fine. So Linda Talon, we're AKA Linda Shakur.
That is my legal name, sir.
How do you spell the last name?
Shakkour.
All right. But at one point you did go by Linda Talon?
Correct.
All right. So you're here on 2020 MM2683AO. It's a warrant for your arrest for failure to appear. The bond in that warrant was $250.
Can-
I'll appoint the Office of the Public Defender to represent you, and I'm going to stay the bond at $250, okay?
Your Honor, there is an offer to resolve.
All right.
I didn't have a chance to speak to her because she wasn't brought up yet.
Mm-hmm.
Could I have just a moment?
Yeah.
So I'm going to ask that you stay the bond, Your Honor.
All right. The bond, as we stated, $250. You have a bond in this case. Good luck to you, ma'am. That's it.
And the attorney will speak with you more. They have to. All the attorneys, so they can go over it with you more.
All right, sir, your name?
Richard Gooch.
All right, Mr. Gooch, you're here. Give me 1 second. In 2023 MO94AO, one allegation of camping. I've reviewed the arrest affidavit, do determine there's probable cause. Was there an offer to resolve this case?
Yes, Judge, an adjudication, credit time served.
All right.
He would like to accept and enter plea of no contest, Your Honor.
All right, Mr. Gooch, you just signed that plea form. Yeah. Did you have the opportunity to go over that plea form? Got to answer out loud, yes or no. I see you shaking your head, but the court reporter's making a record elsewhere, so, okay. Thank you. You understand you have the right to go to trial. This is a criminal offense. You have the right to go to trial on this offense, but by resolving your case here today, there's not going to be a trial, and you're waiving the rights that are listed at the top of the plea form?
Yes, sir.
You on probation for anything else?
No, sir.
You under the influence of any drugs, alcohol, or medication? Or medication that's affecting your ability to understand what's happening here today?
No, sir.
All right. Anyone threaten you or coerce you to enter this plea?
No, sir.
You understand that if you're not a U.S. citizen, a plea of this offense will subject you to deportation?
Yes, sir.
You understand if you've ever been convicted of a sexually motivated or sexually violent offense, a plea to this offense could subject you to involuntary civil commitment?
Yes, sir.
All right. All right, well, accept the no contest plea. We'll adjudicate you guilty, sentence you to, is it 2? 1? It's 2. 2 days in the Orange County Jail with credit for 2 days' time served, plus court costs. I'll give you 1 year from the date of your release to take care of the court costs, or be on a payment plan making regular payments. Otherwise, they'll suspend your driver's license, okay?
Yes, sir.
All right, good luck to you. You have 30 days to appeal the judgment and sentence. All right, sir, your name?
Bonnie Watkins.
All right, Mr. Watkins, you are here on one count of, it's 2023 MO95AO. It's one count of disorderly conduct. I've reviewed the arrest affidavit. I don't find there's probable cause. Based on the statute, there needs to be some allegation that the car that was stopped in accordance to a traffic control device. And there was no allegation that they were stopped in obedience to a traffic control device. So I'm just gonna ROR him as to this. He'll be released as it relates to this charge today, okay?
You don't need that, but they're fine. Go ahead.
All right. Sir, your name? You can come up. We can skip him for a few moments. Y'all tell me when. So just set him to the side. He is coming just later? Okay. All right, thank you. Set her there.
She gives you the-
All right, sir, your name?
Landon Bradley Barnes.
All right, Mr. Barnes. You're here on one count of operating a motor vehicle without a valid driver's license in 2023 CT 65AE. Is there an offer to resolve this case?
Yes, Your Honor, an adjudication, credit time served.
And he would like to accept and enter plea of no contest.
All right, in handed a plea form. Did you sign the bottom of the plea form?
Yes, sir.
All right. You You understand that by resolving your case here today, there's not going to be a trial and you're waiving the constitutional rights that are listed at the top of the plea form?
Yes, sir.
Are you on probation for any other offense?
No, sir.
You understand if you're not a U.S. citizen, a plea of this offense will subject you to deportation?
Yes, sir.
You understand if you've ever been convicted of a sexually motivated or sexually violent offense, a plea of this offense could subject you to involuntary civil commitment?
Yes, sir.
Anyone threaten you or coerce you to enter this plea? Anyone threaten you? No?
No, sir.
All right. You under the influence of any drugs, alcohol, or medication that's affecting your ability to understand what's happening here today?
No, sir.
All right, well, accept the no contest plea, adjudicate you guilty, sentence you to 2 days in the Orange County Jail with credit for 2 days' time served. Also assess court costs, be about just over $300. How much time do you need to pay that?
I'm probably gonna need about a month.
All right, I'll give you 60 days. Take care of the financial obligations, okay?
Yes, sir.
All right, if you don't pay the fines or you're not on a payment plan making regular payments, there'll be a suspension on your driver's license, all right?
Yes, sir.
All right, you have 30 days to appeal the judgment and sentence.
Your Honor, you said he had 1 day, right? 1 day in?
Oh, if he had one, I said two.
And he had,
Two.
oh, I have one, okay. He also has that open Hillsborough County case, so he just needs to be mindful of that.
All right, you have an open Hillsborough County case, there may be a hold on you for that. They may come get you, but you just so you're aware of that. You have an open case in Hillsborough, okay? Probably not, the way he asked that question, but anyway. All right, sir, your name?
Jeffrey Dunn.
All right, Mr. Dunn. You're here on 2023 CT 66AE. It's one count of driving while license suspended or revoked with knowledge. I'll appoint the Office of the Public Defender to represent you. I've reviewed the arrest affidavit. I do find there is probable cause. I'll set bond at $500.
Your Honor, he qualifies for PTR.
Oh, that's right.
Yes, we did.
I would ask for pretrial release.
All right. So we'll release you on pretrial release. It's a non-monetary release, so you'll be released as it relates to this charge today. Okay, the only condition I'm going to impose is do not drive or operate a motor vehicle without a valid driver's license, okay?
Sir.
All right, good luck. All right, sir, your name?
Stanley Baker.
All right, Mr. Baker, you're here on one count of grand theft, third degree of a motor vehicle. Reviewed the arrest, or this is 2023 CF 722AO. I reviewed the arrest affidavit, do find there is probable cause. I'll appoint the Office of the Public Defender to represent you. Based on, you've got 11 prior failure to appears, I'm gonna set bond on this case at $11,000. No other conditions other than that, but you do have the Office of the Public Defender appointed to represent you, okay?
Sumter County. This is where the case is out of.
Not that I know of.
It was reported out of Sumter County.
Yeah, but this is an Orange County case, correct, Your Honor?
2023 CF 722AO is an Orange County case.
Yeah, it's Orange County.
This case, my girlfriend, she reported the vehicle.
Listen, sir, we're not getting into the facts of your case today.
Orange County
You have the right to remain silent. Everything you say can and will be used against you.
jurisdiction, and they can go through that.
It's usually a good idea in these situations to exercise that right, okay? All right, good luck. All right, sir, your name?
Simon Barrientos.
All right, Mr. Barrientos, you're here in 2023 CF 733AO. It's one count of fleeing or attempting to elude a police officer. I reviewed the arrest affidavit. I do determine there is probable cause. You do qualify for pretrial release. I'll appoint the Office of Public Defender to represent you. I'll order you on to pretrial release. Are there any special conditions the state would be requesting?
No, Your Honor.
All right, so you'll be released as it relates to this charge today, okay?
Yes, sir.
All right, good luck.
Thank you so much.
Hi, ma'am, your name?
Ms. Bernier?
You don't qualify. You have history. You have a crime history.
Say your name again, I'm sorry.
Mary Grace Bernier?
All right. All right, Ms. Bernier, you're here in 2023 CF 693AO, one count burglary of a conveyance, one count petty theft of $100 or more. I've reviewed the arrest affidavit. I do determine there's probable cause. I'll appoint the Office of the Public Defender to represent you. Set bond on count one at $1,000, count two at $100, with do not return to the scene where this was alleged to have occurred, okay? All right, good luck.
Your Honor, this is Alan.
Okay. All right, ma'am, your name?
Ashley Allen.
All right, Ms. Allen, you're here on case 2022 CT 703AE. It was a warrant for a failure to appear. Bond in the warrant was $250. Was there an offer to resolve this case?
Yes, an adjudication, credit time served.
Have a moment.
She does have that open case up there as well, so.
She's got an open case where?
Felony, Orange County, 2021 CF 7438.
Is that holding her? Is that holding her? She would like to accept the state's offer and enter a plea of no contest, Your Honor.
All right.
He has 1 day in.
All right, thank you. All right, Ms. Allen. I was handed a plea form. Did you sign the bottom of the plea form?
Yes, sir.
All right, you understand that by resolving your case here today, there's not going to be a trial and that you're waiving the right to go to trial on the criminal traffic offense?
Yes, sir.
All right, and that you're waiving the constitutional rights associated with going to trial on that offense?
Yes, sir.
You understand that? You under the influence of any drugs, alcohol, or medications affecting your ability to understand what's happening here today?
No, sir.
Anyone threaten you or coerce you to enter this plea?
Say that
Did
again.
anyone threaten you or coerce you to enter this plea?
No, sir.
Are you on probation for any other offense?
No, sir, I'm not on
All right.
nothing.
You understand if you're not a U.S. citizen, a plea to this offense will subject you to deportation?
Yes, sir, I'm a U.S. citizen.
Do you understand if you've ever been convicted of a sexually motivated or sexually violent offense, a plea to this offense could subject you to involuntary civil commitment?
Yes, sir.
All right. All right, well, accept the no contest plea. We'll adjudicate you guilty, sentence you to 1 day in the Orange County Jail with 1 day credit time served. You'll get released as it relates to this charge today, okay? Also assess court costs. I'll give you 1 year from the date of your release to take care of the court costs. You have 30 days to appeal the judgment and sentence, okay? Good luck.
Thank you.
All right, ma'am, your name?
Monica Garlock.
All right, Ms. Carlock, you're here on a couple cases. 2023 CF 702AO, it's one count of cruelty to animals. That was pursuant to an arrest warrant, so a probable cause determination's previously been made. Bond in that warrant was $7,500. I'm going to stay bond in that case at $7,500. You're also arrested on 2023 CF 743AO with one count of possession of MDMA, one count of possession of drug paraphernalia. I'll appoint the Office of the Public Defender to represent you in that case as well. I've reviewed the arrest affidavit, do determine there's probable cause. Set bond on count one at $1,000, count two at $100. You're also out on bond in 2023 CF 228AO on one count of possession of MDMA, placed on bond on January 6th. Because of the recency of that case and the nature of the new allegations, I'm going to revoke the bond in that case and set bond at none. I'll appoint the Office of the Public Defender to represent you in that case as well, so they can file any motions, okay? All right, and 2023 CF 702, it's a condition of your bond, you're to possess no animals, okay?
No animals.
That's the attorney's number. You gotta call him. We could try to get a bond up.
I can't do that now.
He revoked it because you picked up this one.
All right, ma'am, good luck. Hi, ma'am, your name? All right, it's 2023 CF 701AO. It's one count of cruelty to animals. It was pursuant to an arrest warrant. So a probable cause determination's been previously made. Bond in the warrant is $7,500. Special condition, you possess no animals. I'm going to stay the bond at $7,500 and impose that condition, you possess no animals. Now, your sister is just in here, just had her bond revoked. And she's being held no bond because she, pursuant to this arrest, was caught possessing MDMA, which she was out on bond for, okay? You were also out on bond for possession of MDMA. By the grace of God or whomever, you did not get arrested for possession of MDMA this time, okay? So I'm not gonna revoke your bond, but I'm letting you know you're out on bond, okay? When you're out on bond, you gotta live a little cleaner than you would otherwise. Otherwise, you get arrested again, you're not entitled to a bond, okay? Like your sister, because she got arrested for possession of MDMA the second time, she's being held no bond right now, okay? All right? So you're not. I'm just, let that be a cautionary tale. You have a bond on the cruelty to animals case at $7,500, but just understand, you're gonna remain out on bond on the MDMA case and the cruelty to animal case. So now you're out on 2 bonds. So if you mess up again, or something happens where you get in contact with law enforcement, you get brought back to jail on a different charge, there's a very good possibility you're gonna be held no bond. You understand that? All right, good luck to you, ma'am. All right, sir, your name?
Luis Alfredo Castro.
All right, Mr. Castro, you're here in 2020 CF 6857AO. I'll appoint the Office of the Public Defender to represent you. You were arrested on a warrant for failure to appear. Bond in that warrant was set at 0. I'm going to stay the bond at 0, okay? All right, good luck.
Your Honor, Davis refused.
And I will,
All right. We'll appoint the Office of the Public Defender to represent Mr. Davis.
and I will waive, Your Honor.
All right, he had a handful of cases. 2023 CF 748AO. I'll appoint the PD in each of the cases. It's 1 count of larceny, petty theft with 2 priors. I reviewed the arrest affidavit. Do determine there's probable cause. Set bond in that case at $1,000. In 2022, MM, and also do not return to the store. 2022 MM 6569AO, it was a warrant for failure to appear. Bond in that case was set at $2,000. I'll stay the bond. 2022 CF 13779O, it's a warrant for aggravated assault with a deadly weapon. The bond in the warrant was $3,500 with special conditions and no contact with the alleged victim, no weapons, firearms, or ammunition. We'll stay the bond with those conditions. 2022 CF 14429AO, it's a warrant for violation of a sex offender violation. The bond was to be set at IA. I'll set bond in that case at $1,000 with the special condition you comply within 2 business days of his release from custody with the reporting requirements. All right. Sir, your name?
Oh, Your Honor, he has 3 cases he's out on bond for.
Who does? Mr.
Juan Davis.
What were the case numbers?
Oh, okay. 2022 CF 11417AO. 2022 CF 11412AO. And 2022 CF 8374AO.
What was the last,
Did you, did we?
what was the last one?
You're on a 2022 CF 8374AO.
All right, give me 1 second.
And Your Honor, on 11417 and 11412, both of those state has not made a filing decision, so state would request no action.
All right,
On the 8374, that's also a sex offender violation case that has been filed on. However, state will leave it within your discretion. I believe that one allegedly happened.
yeah, we'll take
Late
no
2022.
action to those cases that he's out on bond on, okay? All right, thank you. All right, sir, your name?
Hi, my owner. My name is Charles Donaldson.
All right, sir. You're here on one case, 2023 CF 490AO. There's 4 counts pursuant to an arrest warrant. 1 count of home invasion, robbery, 1 count of battery, 1 count aggravated assault, 1 count criminal mischief. I'll appoint the Office of the Public Defender to represent you. Because it was a warrant, a probable cause determination has been previously made by the judge who signed the warrant. The bonds were set by that judge on count 1 at $10,000, Counts 2 and 3, $500, and counts 4, $150. Also with the conditions that you do not return to the scene where that was alleged to have occurred, no contact with the alleged victims, that you do not possess any weapons, firearms, or ammunition. I'm going to stay the bonds of the warrant at the amounts that are currently set with the same conditions, okay?
Your Honor, just for the record, state would be asking for no bond on count one, given that it is a PBL offense, understanding that the judge who signed the warrant, I believe it was Judge Jordan, set it at 10,000.
Yeah, I'm going to stay, I understand. I was surprised to see a bond on it too, but for whatever reason, he set a bond at 10,000, so we're going to stay it, okay?
Understood.
Just so you know, you're not entitled to a bond on count one. The judge who signed the warrant sets a bond anyway, so you caught a break there. But if, while you're out on bond, you got to live a little cleaner than you would otherwise, because if you get picked up doing anything else, you're no longer entitled to a bond. You'll be held no bond, okay?
Okay,
Right.
my honor, I can say anything?
Well, you have the right to remain silent. Everything you say can and will be used against you. It's probably not a good idea to talk about the facts of your case, or even ask questions about it. You have an attorney appointed to represent you. I would direct your questions to them, okay? All right, good luck. All right, sir, your name? All right, Mr. Edwards, you're here on a few cases. 2023 CF 749 AO. It's 3 counts. 1 count of fleeing and attempting to elude, 1 count of possession of methamphetamine, 1 count of resisting an officer without violence. I'll appoint the Office of Public Defender to represent you in that case. Reviewed the arrest affidavit. Do determine there is probable cause for each offense. Set bond on count 1 at $5,000. Count 2, $100. Count 3 at $100. You're also arrested pursuant to an arrest warrant in 2022 CF 11361 AO. Bond in that warrant is $1,500. We'll stay the bond at $1,500 on that case. You're also arrested pursuant to an arrest warrant on 2022 CF 7177 AO. Possession of ammunition by a convicted felon. The bond in that warrant was $2,500. We'll stay the bond in that case at $2,500. Add the condition you possess no weapons, firearms, or ammunition. You're also out on bond for fleeing and eluding on 2021 CF 14486 AO. So to that, we're going to revoke the bond, set bond at none in that case. I'll appoint the office of, I think the Office of the Public Defender was previously appointed in that case, but if they weren't, we'll appoint them to represent you in that case as well.
No, this is a new charge.
All right, good luck, sir. Yep. All right, sir, your name?
Malik Gaither.
All right, Mr. Gaither, you're here on 2022 CF 14178 AO. 1 count of sex offender violation, failure to update your information. Reviewed that came in, it was a warrant. Bond in the warrant was to be set at IAs. I'll set bond at $1,000. Also order that you comply with the reporting requirements within 2 business days of your release, okay? Also appoint the Office of the Public Defender to represent you in that case. You're also out on bond in 2022 MM 7860 AO is 1 count of battery. Court's inclined to take no action on that case unless somebody has a better idea.
Okay, Your Honor.
Okay. All right, so we're taking no action on the case you're out on bond on, okay? All right, good luck.
Thank you.
Mm-hmm. All right, sir, your name?
Anthony Goins.
All right, Mr. Goins, you're here in 2023 CF 746 AO, excuse me, 1 count of possession of MDMA. I'll appoint the Office of the Public Defender to represent you in the case. I reviewed the arrest affidavit. Do determine there's probable cause. Set bond in that case at $1,000, okay? All right, good luck. All right, sir, your name?
Patrick Graham.
All right, Mr. Graham, you are here in 2023 CF 758 AO. 1 count of fleeing and eluding, and 1 count of aggravated fleeing and eluding with injury or damage. This was pursuant to an arrest warrant. So probable cause determination's been made. Bonds were to be set at IA. I'm gonna set bond on count 2 at $10,000, count 1 at $100. State, do you have a position on the 2022 CF 12016 AO, the count he was out on bond on?
Your Honor, it has been filed, however, state will leave it within your discretion.
It has been filed on?
Just the carrying a concealed.
Just the carry and conceal? When was he out on bond on that?
He was arrested 10/15 of 22. He bonded. He also bonded 10/16.
10/16/22?
Yes, sir.
Your Honor, given that they're unrelated, I would ask that you take no action on the out on bonds. He has very limited criminal history. No failures to appear. And I can't see the dates. You check the date of the warrant? I can't see it.
All right. As a condition of your bond in the 2023 case, I'm also going to order that you do not possess any weapons, firearms, or ammunition. All right. Based on the fact you were out on bond, I'm going to revoke the bond in that case and set bond at none until further order of the court. I mean, admittedly, it's a close call, but when you're out on bond, you gotta live life a little cleaner than you would otherwise, and running from the police is, like, I get it, but you're out on bond, you can't do it, all right? So, good luck to you.
Could you see the dates, Your Honor? On his, out on bond, we were trying to check the dates. I can't see the warrant.
I can't, but given the, I didn't see the exact dates, but given the,
That's what we were checking, because,
I reviewed it and I made a note of that, and it looks, where did I see? Oh, the Florida Highway Patrol case has a 2023 case number. So I deduced from that, and since he was out on bond on October of 2022.
yeah, but sometimes they come in later, which is why we normally check. Your Honor, I can't see the warrant, so I don't know when.
Well, if it needs. Do you have the affidavit? Does anyone have the affidavit that was?
No one has it.
It's not showing me.
It doesn't let you pull up anything.
Just the retainer, not the affidavit. The retainer doesn't have a date on it.
Because the warrant would be drafted by Florida Highway Patrol and submitted.
Yeah.
And since it was drafted with a 2023 case number, court's making the determination that if I'm wrong, if anyone gets the facts, but it's safe to say that this happened in 2023, the allegations within the affidavit, even though we don't have a copy of the affidavit, the fact that it was submitted with the 23 FHP case number.
I see that it was signed on the 16th, and you got picked up at the courthouse on the 17th. Those are the only dates.
Okay.
Like I said, if we get the affidavit and we're wrong,
Yeah, no one has the affidavit, which is.
State has no objection to no action, however,
All right, well, let him know he dodged a bullet, because I mean, yeah, we can't really tell.
No action.
Yeah, sorry. No action, yeah, due to, I guess, without the affidavit, we can't definitively, I mean, that's true. I am assuming that based on the case number, those allegations happened while he was out on bond, but. All right, sir, your name? All right, Mr. Hollenden, you're here in 2022 CF 12045 AO. Warrant was issued for violation of condition of pretrial release. The bond in that warrant was at none. I'm going to stay the bond at none. I'll appoint the Office of the Public Defender to represent you in this case, okay?
Your Honor, Kearney, review.
All right, he was here on, just on 2023 CF 727, right?
Yes.
All right.
Yes, Your Honor.
We'll appoint the Office of the Public Defender to represent him in that case. You waive his appearance?
Yes, Your Honor.
All right, he was arrested pursuant to an arrest warrant, probable cause determinations previously made. One count of robbery by sudden snatching, bond in the warrant was $5,000, will stay the bond at $5,000. One count of battery, bond was $1,000, will stay the bond at $1,000 with the conditions, no contact, no return, no weapons, firearms, or ammunition.
Doesn't matter why. Doesn't matter why. No, it's somebody else's warrant. That's all.
All right, sir, your name? All right, Mr. Littles, you're here on 2022 CF 7095BO. It was a warrant issued for your arrest for failure to appear. I'll appoint the Office of the Public Defender to represent you. The bond in the warrant was set at none. I'm going to stay the bond at none, okay?
There's no way that I can get one, Your Honor?
You got to show up to court. So when you fail to appear, you're no longer entitled to a bond, so.
But I was fed the wrong information. I called, but they still fed me the wrong information.
Well, that, until you go see the judge that signed the warrant or the other judge in that division, whoever issued the warrant issued the bond at none, so I'm staying at what they issued it at, okay? All right, good luck. All right, sir, your name, or ma'am?
Nevaeh Mosher.
All right. All right, Ms. Mosher, you're here. Give me 1 second. I'll appoint the Office of the Public Defender to represent you. Get the case number. Okay. 2023 CF 762AO. A warrant was issued for your arrest. One count of home invasion robbery. The warrant has a bond set at none. It was also checked that it may be modified by the first appearance judge. I don't have an affidavit. State, do you have one?
No, Your Honor.
This would be a life felony.
Yes, Judge. It is a PBL.
Your Honor, she has a very limited criminal history. I don't see anything. I see something from Georgia, but other than that, she has no convictions.
The only thing she currently has within Orange, other than this case, she has an open non-arrest felony, an ag assault, and a criminal mischief, both F3s.
So I'll ask that you use your discretion to set a bond in this case, Your Honor. I don't like it.
Here's the thing, because we don't know the facts.
Give me the case number, Your Honor.
Yeah, it's 2023 CF 762AO. Here's what we're gonna do. Because there's been a probable cause determination that a punishable by life felony has been committed, without knowing more, the court's not inclined to grant a bond at this time. based on the nature of the offense itself and that a probable cause determination's been made. Also order that you have no contact with the alleged victim, no return, and that you possess no weapons, firearms, or ammunition. Once you learn it, I haven't already, I'll appoint the Office of the Public Defender to represent you, and they can file any appropriate motions to try to have that bond modified. Okay, but without knowing more, I'm just not gonna set a bond at this time, okay? Good luck, ma'am.
So here. Let's see if I can, I'll just this paper. No.
All right, sir, your name?
Andre Tran Nguyen.
All right, Mr. Nguyen. You're here in 2023 CF 696AO, one count of possession of fentanyl, one count of possession of drug paraphernalia. I'll appoint the Office of the Public Defender to represent you. Reviewed the arrest affidavit, do determine there's probable cause. Set bond on count one at $2,000 and count one at $100. What's that? Count two at 100, yeah, count one at 2,000, sorry. All right, good luck to you, sir.
Your Honor, Raven bonded,
All right,
Rivera Rohina bonded,
all right.
Sheldon refused.
I'll waive, Your Honor.
All right, we'll appoint the Office of the Public Defender to represent Christopher Shelton in 2023 CF 734AO, one count of possession of MDMA. Viewed the arrest affidavit, do determine there's probable cause. He's also being held on a out-of-county warrant. Do we know the bond on that warrant?
The bond on the out-of-county, Your Honor, is $10,013. He was seen on that yesterday.
Okay. What's with the $13? What county does that? Is that, no one has to answer. I was just curious. I'm sure there's some reason behind it. All right, sir, your name?
And also, Your Honor,
Oh.
Silva bonded.
Silva?
Yes.
I don't know if I even had Silva. It's okay. Next one I have is Smith. Is Anthony Smith? Okay. All right, sir, your name? Smith. All right, Mr. Smith, you're here on case 2021 CF 13958AO. It was a warrant for your arrest for failure to appear. Warrant set the bond at $5,000. I'll appoint the Office of the Public Defender to represent you, and I'm going to stay the bond at $5,000, okay? All right, so, ma'am, your name?
Sarah Beth Suffield.
All right, Ms. Suffield, you're here on 2022 CF 2418AO. I'll appoint the Office of the Public Defender to represent you. You're arrested on a warrant for your failure to appear in that case. The bond by the judge that signed the warrant was set at none, so I'm going to stay the bond at none in that case, okay? Good luck.
Today? No, call you.
All right, sir, your name?
Marquise Turner.
All right, Mr. Turner, you're here on 2023 CF 699AO. It's 4 counts, possession of MDE with intent, possession of a controlled substance, possession of cocaine with intent to purchase, fleeing and eluding, and possession of a controlled substance. I've reviewed the arrest affidavit as to each count, find there is probable cause. Set the bond on count 1 at $1,000. Or,
Your Honor, I think he's only here on the failure to appear.
oh, we've already,
Is that incorrect?
He's got, yeah, he's.
well, I'm gonna set bond on count 1, with intent to, hold on, I can't read my handwriting. What's it? Yeah. That looks, okay. Yeah, I'm gonna set bond on count 1 at $20,000. We'll set bond on count 2 at 500, count 3, 500, count 4 at 500, and count 5 at 500. You're also here on a warrant for your arrest in 2020 CF 10068AO. That was a warrant for a failure to appear in that case. The judge who signed that warrant set the bond at 0, so I'm gonna stay the bond at 0 in that case until further order of the court, okay? Good luck.
You could drop the bond back down on the first one?
You've got attorneys appointed to represent you. Any motions that addressing that bonds, they can file those, okay? But you're being held no bond on the failure to appear right now anyway, so.
No, I ain't tripping about that.
Yeah, yep. All right, ma'am, your name? All right, Ms. Wing, you're here on 2023 CF 745AO. 1, 2, 3, 4, 5 counts. First count is possession of heroin. Second count, possession of methamphetamine. Third count, possession of cocaine. Fourth count, possession of fentanyl. Fifth count, possession of drug paraphernalia. I've reviewed the arrest affidavit. Do determine there's probable cause as to each count. Set bond on count 1 at $200, count 2 at $100, count 3 at $100, count 4 at $7,500, and count 5 at $100. Okay? And I'll appoint the Office of the Public Defender to represent you. All right, sir, your name? All right, Mr. Wright. You're here in 2022 CF 5070AO is a warrant for your arrest for a failure to appear in that case. The judge who signed the warrant set the bond in that warrant at 0. I'm going to stay the bond at 0, okay, until further order of the court. All right, good luck to you. Gautier.
2300 1422. I'm sorry. 23001422.
Okay, and took no action on the case.
Bonded.
Gaither? Which, oh,
And then, 23001487.
Bonded.
thank you, everyone. See you tomorrow. Yes. All right, sir, your name?
Clarence Bateman.
All right, Mr. Bateman. You're here on 3 cases, 2022 CF 2272AO, 22 MM 8412AO, and 2022 CF 3478AO. I'll appoint the Office of the Public Defender to represent you in each of those cases. In 2022 CF 2272AO, there was a warrant issued for a violation of probation. The bond in that warrant set at none. I'm going to stay the bond at none in that case until you have the opportunity to, until further order of the court, okay? 2022 MM 8412AO, that's one count of battery, domestic violence. That was also pursuant to a warrant, so a probable cause determination's been previously made. I'll set bond in that case at $500. I have to order that you have no contact with the alleged victim, that you possess no weapons, firearms, or ammunition, and that you do not return to the scene of where this occurred, okay?
Sir.
All right. No contact means no contact, too. I'm sure your attorney will tell you the jail phones are recorded. No contact through third parties, no Facebook, TikTok, Instagram, anything like that. So no contact with the alleged victim as a condition of your bond in that case. There's also a warrant for failure to appear in 2022 CF 3478AO. Bond is set in that case at none as well, okay? So I'm going to stay the bond in that case as well. All right, good luck to you, sir. All right, sir, your name?
Robert T. Cooks Jr.
All right. All right, Mr. Cooks, you're here in 2023 CF 752AO. It's 1 count of battery by strangulation, domestic violence, and 1 count of battery, domestic violence. A warrant was issued for your arrest in that case, so a probable cause determination has been made in each count. Bond were set in that case at $2,500 and $250 with the following conditions: no contact with any of the alleged victims, no return to the scene, that you do not possess any weapons, firearms, or ammunition. You're also out on bond on 2022 CF 8780AO, also for a battery. Because you're out on bond on a battery and got another battery, we're going to have to revoke your bond and set it at none in that case until further order of the court. I believe you already have an attorney, and in that case, you're out on bond, but if not, I'll appoint the public defender in each of your cases. So you have an attorney who can file whatever motions you need to be filed, okay?
Your Honor, I'm just checking the dates because I couldn't see the warrant. I don't know.
I checked,
You already checked them.
hold on.
I could see the out on bond, but I can't see the date for the new case.
Well, it's a 2022. CF, the one he was out on bond on, and then the latest is 2023.
It's January of 2023.
Oh,
Yeah.
thank you.
January 16.
Morning.
All right, sir, your name?
My name is Pablo Cruz.
All right, Mr. Cruz, you're here in 2023 CF 551AO. It's a warrant was issued for your arrest with 5 counts. So probable cause determination has already been made as to the following counts: aggravated stalking after an injunction, violation of a domestic injunction, another count of violation of domestic injunction, and 2 counts of violation of pretrial release condition on domestic violence case. On count 1, the bond was set at $10,000. I'm going to stay the bonds on each of those counts. So $10,000 on count 1, $1,000 on all the other cases. My records indicate that in 2022 CF 9186AO, on 12/27, the court granted a motion for pretrial detention, so it's being held no bond on those cases. So I'm not going to take any action on those and just stay the bonds that came in on the warrant in 551AO. I'll also appoint the Office of the Public Defender to represent you, okay? Oh, yeah, conditions are, yeah, it's going to be the same conditions that, quite frankly, you weren't able to follow the first time, but it's no contact with any of the alleged victims, no weapons, firearms, or ammunition, do not return to the scene, okay?
On the warrant, it has, no drugs or alcohol.
All right, thank you. So on the warrant, I'm going to stay those conditions too. No drugs or alcohol and maintain separate residence, okay? All right, good luck. All right, sir, your name?
Matthew Pastor.
All right. All right, Mr. Pastor, this is 2023 CF 755AO. There's 2 counts. 1 count of aggravated battery with a deadly weapon, domestic violence, and aggravated battery on a person 65 years of age or older with a deadly weapon. I've reviewed the arrest affidavit. I do find there's probable cause. I'm going to appoint the Office of the Public Defender to represent you in this case. I'm going to set bond on count 2, the aggravated battery on a person 65 years of age or older with a deadly weapon at $5,000, and on count 1 at $100. Because there's no victim here, I have to order that you have no contact with the alleged victim, that you do not return to the residence, and that you possess no weapons, firearms, or ammunition. I will allow you to go back to the residence one time with the presence of law enforcement to get any personal belongings you may need, okay?
Yes.
How that works is you call law enforcement first, okay? Don't show up and then call the cops. You call law enforcement first, coordinate a mutually agreeable time for everyone for you to go over there and get your stuff. Then you can go, and then other than that, yeah, you can't go back to that residence until further order of the court, okay?
Okay.
All right, good luck, sir.
You too.
All right, sir, your name?
Marcus Patman.
All right, Mr. Patman, you're here on 2 cases. I don't have a case number for the one, the Orange County case. Yep. 756. All right. First case, 2023 CF 756AO, there's 2 counts, aggravated battery, domestic violence, and 1 count of obstructing, hindering witness communication to law enforcement. I've reviewed the arrest affidavit. I do find probable cause as to each count. I'll appoint the Office of the Public Defender to represent you. Set bond on count 1 at $7,500 and $500 on count 2. You're also here on a violation of probation warrant out of Palm Beach County. That bond's set at none, so I stay the bond at none on that. So you're going to be held up, no bond on the VOP warrant until Palm Beach County comes get you, okay? Conditions, yeah, no. The conditions of your bond here are that you have no contact with the alleged victim. You do not possess any weapons, firearms, or ammunition. Do not return to the scene. And as it relates to no contact, just understand no contact means no contact. No phone calls, emails, text messages, contact through third parties, anything like that, okay? All right, good luck, sir. All right, sir, your name?
Exhibit Paul.
All right, Mr. Paul, you're here in 2023 CF 711AO. You're arrested pursuant to a warrant with 2 counts, aggravated battery with a deadly weapon and false imprisonment. So a probable cause determination has been previously made as to each count. Court's gonna set bond on count one at $5,000 and count two at $100. Order that you have no contact with the alleged victim, okay? I'll appoint the Office of the Public Defender to represent you in this case. But no contact means no contact, no phone calls, emails, text messages, anything like that, no contact through third parties. That you do not return to the scene where this was alleged to have occurred, and that you do not possess any weapons, firearms, or ammunition, okay?
Sir.
All right, good luck to you, sir.
Your Honor, forgive me, Your Honor, I have sinned. I ask for your mercy. I'm a loving father.
It's okay. All right, sir. Sir, your name?
Jason A. Steele.
All right, Mr. Steele, you're here in 2020, well, two cases. 2023 CF 694AO. It's one count of petty theft of $100 or more and one count of burglary of a conveyance.
Totally false.
Hold on. You're also here on 2023 CF 757AO, which is two counts aggravated stalking, domestic violence, and a violation of domestic injunction. With regards to 2023 CF 694, I'll appoint the Office of the Public Defender to represent you in each of those cases. As it relates to 694, is there any probable cause arguments? As it relates to, this was, I think the witness saw a woman take something out of the back of the truck and then run across the street to where he was standing.
And he was like a lookout. State would just argue under principal theory, it's enough for PC. I'm not
Okay.
sure if we would file on it. However, under principal theory, I think there's enough under PC.
Your Honor, may I ask?
Hold on. We're not talking about the facts of your case. We're just setting conditions of release and setting in bonds today. I have to take whatever's written in the arrest affidavit as true, whether it's true or not. I don't necessarily think everything in there is true as it relates to you and everyone else. But for the purposes of today's hearing, we just determine whether probable cause is established in what the cops wrote down, okay?
May I ask you a question?
Let me tell you this, you have the right to remain silent. Everything you say can and will be used against you. Everything's being recorded. I don't want you to talk about the facts of your case.
No, I'm not gonna do that, Your Honor. I just wanna say to you, again, I'm a loving father who hasn't seen his kids in 3 months. I happen to run into somebody. and-
Well,
and-
you're talking about the fact.
No, I'm not, and I would just like to say to you, Your Honor, if you can forgive me, I will meet any conditions of the court. It's just, I literally work 2 jobs to take care of myself. If this fails, my life goes to shambles. Like, I get out and I go to a homeless shelter, and I have no belongings.
All right. No, I understand. Forgiveness is something that's above my pay grade, so I'm just here doing the law, okay? So, so I do find there's probable cause in 2023 CF 694AO under the principal theories put forth by the state. So, we'll set bond on the petty theft of $100 or more at $500 and of the burglary of a conveyance at $100. In 2023 CF 757AO, the aggravated stalking in violation of a domestic injunction, if court does find there's probable cause, or that was a warrant, wasn't it?
It's a PC affidavit.
It was, okay. I reviewed it. The court does find there is probable cause. We'll set bond on count one at $5,000 and count two at $100. The problem for you, sir, and I think that you've recognized, is that you're out on bond. In 2022 CF 11855AO, counts of child abuse and false imprisonment where the injunction and no contact order was in effect, and you essentially had contact with the same victim. So in that case, I've got to revoke your bond and set it at none. Order that you have no contact with the alleged victim. No contact means no contact. Emails, no. When you're out on bond and you violate the conditions of the bond, you're no longer entitled to a bond. That's what the law says, so.
So how soon can I?
I've appointed the Office of the Public Defender to represent you. They can file whatever motions
To try to set bond.
you need to be filed, but in this case, you'll be held no bond, And-
It could be months, it depends on how quick.
no contact, no weapons, firearms, ammunition, and no return.
So there's nothing that could be done, like you can't restate the bond, reissue the bond?
Not at this time, so.
See, my messed up.
All right, good luck, sir.
Thank you.
All right, sir, your name?
Gabriel Cuyo.
All right, sir, you're here in 2023 CF 712AO, aggravated battery on a pregnant person. I've reviewed the arrest affidavit. I do find there is probable cause. I'll appoint the Office of the Public Defender to represent you. I'll set bond in your case at $3,500 with the following conditions: that you have no contact with the alleged victim, you maintain separate residences. I'll allow you to go back to the residence one time with the presence of law enforcement to get any personal belongings. The way that works is you got to call the police first and set up a mutually agreeable time for you to go over there and get your stuff. But other than that, you can't go back to the residence until further order of the court. Also order that you possess no weapons, firearms, or ammunition, okay? All right, good luck, sir.
Thank you.
All right, ma'am, your name?
Melissa Boquero.
All right, Ms. Becerra, you're here in 2023 MM383AO. It's one count of battery domestic violence. I reviewed the arrest affidavit. I do determine there's probable cause. You do qualify for what's called pretrial release. Pretrial release is a non-monetary release, so you'll be released. I'll order you on pretrial release. You'll be released as it relates to this charge today without having to post a bond, okay? But there's going to be some conditions. Conditions are, because there's no victim here, you cannot have contact with the alleged victim in this case, okay? No, you can possess no weapons, firearms, or ammunition. And you can't go back to the residence where this was alleged to have occurred. If you need to go back to the residence one time with the presence, to get any personal belongings, I'll allow you to do that with the presence of law enforcement, to get anything, that you may need. Again, you may have heard me before, but the way that works is you call the cops first, set up a time that's mutually agreeable for you to go over there, and then you can go over there and get your stuff. Other than that, you can't go back. And, don't show up there and then call the police, because that may be a violation, okay?
And Your Honor, DCF was contacted in that case.
All right, as a condition of your pretrial release too, I'm also going to require that you comply with any requirements of DCF, if there are any, okay? Well, here's the thing. You're going to be released as it relates to this charge today with those following conditions. That's the only thing we're doing for today's hearing, is determining terms of conditions of release. So I've appointed the Office of the Public Defender to represent you. You have an attorney appointed to represent you. You have the right to remain silent. Usually in this situation, it's usually a good idea to exercise that right, but if there's something else you want to say, knowing that you have the right to remain silent, did you want to ask a question?
No, I was just gonna ask, I can just go without a bond, you said? Is that what you said?
You're being released under what's pretrial release. All that'll be in your paperwork. There's going to be a degree of supervision, okay? So you may have like a pretrial release, like a probation officer you may have to check in with, and then if you violate those conditions, it'll be a violation of your pretrial release, and you'll be brought back into jail, okay?
Does that mean I have a trial coming up or something?
You'll get court dates that you'll, in the future, possibly.
Okay.
But you have an attorney appointed to represent you. You've got the information how to contact their office, so any questions you have related to this, your criminal case, direct those to your attorney.
Okay.
All right? Good luck.
Hello, good morning.
Good morning, sir. Your name?
Terrell Brown.
All right, Mr. Brown, you're here in 2023 MM384AO, one count of battery, domestic violence.
Yes.
I've reviewed the arrest affidavit. I do determine there's probable cause. I'm going to appoint the Office of the Public Defender to represent you. You're also out on bond with, on the charges of aggravated assault with a deadly weapon in 2022 CF14811AO. I've reviewed the allegations in that case as well. Based on the allegations in this case and that case, I'm going to revoke your bond in that case, set bond at none. I'm going to appoint the Office of the Public Defender to represent you in each case. So you have an attorney appointed to represent you. On the 2023 MM384, I'm going to set bond at $500 with the following conditions: that you have no contact with the alleged victim, you do not return to the residence where this was alleged to have occurred. If you need to go back one time with the to get any personal belongings, you can go back with the one time the presence of law enforcement to get any personal belongings, but other than that, you can't go back to the residence. Again, no contact with the alleged victim, and that you do not possess any weapons, firearms, or ammunition, okay? All right, good luck.
Yes, sir, thank you. So I'm trying to understand. So who I have to call?
Good luck, sir. That's all that's happening today. All right, you're good, yep. All right, sir, your name?
Gerald Threat.
All right, Mr. Threat. You're here in 2023 MM37AW. Just It's one count of battery domestic violence. I've reviewed the arrest affidavit, do determine there is probable cause. You do also qualify for what's called pretrial release, so you'll be released I'll order you on pretrial release. You'll be released as it relates to this charge today without having to post a bond, but there's gonna be some conditions, okay?
Yes, sir.
Because the alleged victim's not here, I have to order that you have no contact with the alleged victim until further order of the court, okay?
Yes, sir.
I also have to order that you do not return to the residence where this was alleged to have occurred. If you need to go back one time to get any personal belongings, you may do so only with the presence of law enforcement, okay?
Yes, sir.
Also have to order that you possess no weapons, firearms, or ammunition as conditions of your release. Other than that, any other conditions, State?
No, sir.
Well,
No,
I
Your
was
Honor.
asking the State. That's all right. Any other conditions?
No, Your Honor.
All right. All right, if I didn't already, I'll appoint the Office of the Public Defender to represent you, so you have an attorney appointed to represent you. So if you need that modified for any reason, just direct those questions to your attorney, okay?
Thank you, sir.
You're welcome.
PTO.
All right, sir, your name?
Matthew Atkinson.
All right, Mr. Atkinson, you're here for out-of-county warrant. I'll appoint the Office of the Public Defender to represent you provisionally while you're here in Orange County. You're being held no bond, and in accordance to that warrant, the court's going to stay the bond at none pursuant to that warrant, okay? All right, good luck, sir.
Good morning, Your Honor.
All right, sir, your name?
My name is Marcel, M-A-R-C-L, Mensik, M-E-N-S-I-K.
All right, Mr. Mensick, you're here for a warrant out of county. It's for a failure to appear. The bond in that case is $3,013. The court's gonna stay the bond at $3,013, so you do have a bond on that case. But if you bond out, you probably need to go back to the county wherever this warrant was issued and check in, okay?
Say something, Your Honor.
You have the right to remain silent. Everything you say can and will be used against you. We've already set the conditions of your release pursuant to the warrant. I would advise you not to talk about the facts of your case, but
Okay, just quickly, 1 minute only, please. And sorry, I'm Europeanized to have the accent. 3 years ago, this case should be dismissed. We reunited with my wife. She dismissed that case. And we live in a hotel here, and I take care about her 3 years after COVID. Okay, we almost died. And we are unfortunately having no cash because we invested to the business. So she's waiting in a hotel.
Right.
I managed after 10 hours to talk to her at night.
here, I'm gonna stop. I mean, what are you asking me to do? I'm
I
curious.
have no money now to pay the bond, and I need to take care about her because she's don't see properly. If you can to somehow manage the
No,
I
it's
can go back
it's
to
an
hotel.
out-of-county warrant. It's not even, I'm an Orange County judge. It's an out-of-county warrant. I'm gonna stay the bond at what the judge over there put it in, so if
I
you,
have no money to pay it, and I need to go back to, we are very close to finish business, invested all our money.
Yeah.
She can be on the street next few days if we don't pay hotel. And we find out that was there in the system still yesterday, but it should not to be there.
your bond stayed at $3,000 and $3,013,
Can I
okay?
negotiate somehow with them that I pay later, maybe
No.
1 or 2 weeks?
Bye.
Okay, thank you very much.
Yep. Tola bonded, okay. All right, ma'am, your name?
Rebecca Agosto.
All right, Mr. Agosta, or Miss Agosta, you're here on 2018 CF 18188AO. It's a violation of community control. The warrant signed for your arrest, set bond at 0. I'm gonna stay the bond at 0 in those cases, okay?
Can I express myself about this?
No, you're,
Okay, thank you.
yep. I'll appoint the Office of the Public Defender to represent you, so if they want, if they weren't appointed already, but I'll appoint them to represent you, so any motions to get a bond or anything like that, well, you can do that, okay? All right, sir, your name?
Robert Bargner.
All right, Mr. Bogner, you're here on 2019 CF 2740AO. One count of failure of defendant, it's a warrant issued for arrest for a failure to appear in a violation of probation. Bond in the warrant was set at 0. I'm gonna stay the bonds at 0, and I'll appoint the Office of the Public Defender to represent you, okay?
You don't get a bond, call the attorney so they can file a motion, because you're not getting one today.
Ask you a question, sir. So I contacted Miss Danielle Beasley because I was in drug court, so that's what all of this was about. So I contacted her and let her know that I want to turn myself in, you know, so that we can get it taken care of. And I was under the impression that she was speaking with my public defender, Mrs. Real.
Well, you might want to give them a call, because whatever happened, a warrant got issued for arrest and the bond was set at none, so the bond's none until you see that judge, okay? All right, ma'am, your name?
Kayla McGregor.
All right, Ms. Greger, you're here in 2021 CF 14075AO. One count of violation of probation pursuant to the warrant for violation of probation. Bond was set at 0. I'm going to stay the bonds at 0, okay? I'll appoint the Office of the Public Defender to represent you, so you have an attorney appointed to represent you, but you're going to be held no bond.
You're gonna have to call the attorney, because he's not gonna do it today.
Your Honor, Morgan refused.
All right, I'll appoint the Office of the Public Defender to represent Morgan in 2021 CF 8572AO. He was arrested on a warrant for violation of community control. Waive his appearance?
Yes, Your Honor.
All right, we'll stay the bond at 0 as it is in the warrant, okay? All right, sir, your name?
Walter Purdy.
All right, Mr. Purdy, you're here in 2023 CF 747AO. One count of possession of cocaine, one count of possession of amphetamine. I've reviewed the arrest affidavit. I do find there's probable cause for each of those counts. I'll set bond on count 1 at $1,000, count 2 at $100. 100. Was it 150 on the? All right, I'll stay at 150 on count 2. You're also were on probation in 2016 CF 4241AO. Based on the new law violations, I'll set bond on the VOP at 0. I'll appoint the Office of the Public Defender to represent you in that case, so any appropriate motions can be filed by your attorney, okay? All right, good luck to you, sir.
Your Honor, Thomas refused.
All right, this is 2020 CF 12172AO, violation of community control. We'll appoint the Office of the Public Defender to represent Mr. Thomas. You waive his appearance?
Yes, Your Honor.
All right, this bond was set at 0 pursuant to the warrant. We'll stay the bond at none. All right. 33-day motions, 2022 CF 14528AO, Levon Haynes.
Granted, notice and on filing.
What's that, 18th, all day long? All right, 2022 CF 14569AO, Moore.
Denied, and information was filed.
2022 CF 14585AO, Ortiz Garcia.
Granted, notice and on filing.
All right, 2022 CF 14599AO, Riddle.
Denied, and information was filed.
2022 CF 14591AO, Lyle.
Granted, notice and on filing.
All right. Then he also had 2022 MM5AW.
I believe it's MO. That is a
Oh, MO,
city
yes.
case. I did reach out to the city prosecutor. He said it's with the Ocoee city prosecutor.
All right.
I haven't gotten a response. However, I don't see an information filed.
We'll grant the motion. All right, 2022 CF 14573AO, Brian.
Granted, notice and on filing.
Twenty CF 14228AO, Brown.
Granted, it was no build.
2022 MM8432AO.
Denied, and information was filed.
And 2022 CF 14562AO, Davis.
Denied, and information was filed.
All right, and that does it for this morning. All right, thank you, everyone. At 11:30.
For the case that I'm here for.
I assume it is.
It's actually Uzbek that the defendant speaks, not Russian.
Okay.
What is the language?
Uzbek.
Uzbek? I will try to see if I could get an interpreter for that, but usually those things are done hours prior to IAs.
His interview wasn't English.
Mr. Williams, have you spoken to that defendant?
Yes, Your Honor, and he doesn't understand English.
I'm sorry?
Yes, he doesn't understand English.
Also, pretrial release spoke to the defendant this morning, and
I'm sorry?
pretrial release spoke to the defendant this morning a couple of questions, and we weren't advised that he needed a translator.
All right, we'll deal with that when we reach that case. Madam Clerk, do you need a moment?
No, Your Honor.
All right. Then addressing the state of Florida versus Xavier Carlisle.
Your Honor, if I may, the jail staff is asking me if we could call Joshua Carey first. He's in the back, he's having some behavioral issues.
All right, that is not a problem. 2023 CF 168, the state of Florida versus Joshua Carey. Good afternoon, sir. Please state your name and date of birth.
Joshua Carey, October 13th, 1990.
All right, thank you, Mr. Carey. You're here for an initial appearance after an arrest for misdemeanor battery, hindering communication to law enforcement, and resisting law enforcement officer without violence. You've indicated here you're seeking appointment of the public defender to represent you, so I'll provisionally appoint the public defender to represent you pending a determination of indigency. Mr. Williams, did the defense wish to be heard with respect to probable cause?
Yes, Your Honor, specifically in the resisting arrest without violence charge. While the affidavit does indicate that Mr. Carey was verbally abusive to hospital staff, there is nothing in the affidavit to indicate the officer ever gave him an order or command before he was pinning him on the floor, so the resisting charge does not have the presence of the officer enacting like a legal order before you try to enforce it.
Ms. Boudin?
Your Honor, nothing from the state.
Does the state want more time as to that charge?
I was going to say if the court is inclined to give us 24 hours, I can reach out to the officer for more information.
All right. Then the court will find probable cause for the offenses of misdemeanor battery and hindering communication to a law enforcement officer. Court will find the charging affidavit does not demonstrate probable cause for the offense of resisting a law enforcement officer without violence. And the state will have 24 hours to file supplemental probable cause affidavit. Did the defense wish to be heard as to bond?
Yes, Your Honor. Mr. Carey has a Baker Act hold that was informed by our Social Services Department, and if he were to get pretrial release, he would be receiving treatment from Park Place upon that release.
He does not qualify, I'm told, for pretrial release. State wish to be heard as to bond?
Your Honor, state would ask the court to have the bond remain as to what it is set. These are charges alleging violence. The state has not had the opportunity to speak with the victim due to how recent the events are. And the officer did see the battery on surveillance footage, so we would ask that the bonds remain the same as set.
So under the circumstances, are you also requesting no contact and no return?
Yes, Your Honor.
Mr. Williams, did the defense wish to be heard any further?
Just to take into account the Baker Act hold, Your Honor, in terms of his mental state while committing the alleged offense, and we ask that on the hindering the communication, if the court could set a reasonable bond on that charge.
Bond with respect to the hindering communication to law enforcement officer is reduced to $1,000. Bond is reduced as to the battery charge in the amount of $150. And I guess, Ms. Burden, we'd be setting bond with respect to the resisting law enforcement officer, even though the state is still, or am I gonna ROR him at this point?
The state has no objection if the court wants to ROR on count.
All right, and the defendant is released on his own recognizance, understanding he's subject to a Baker Act hold with respect to the charge of resisting law enforcement officer without violence. Anything else on the case?
Your Honor.
Additionally, the defendant is to have no contact with the alleged victim and no return to the scene of the offense.
Are we striking 24-hour reset for state attorney? Or are we still keeping the 24-hour?
No, I'm RORing him on that count. Mr. Williams, were there any other requests by jail staff as to order of cases?
No, Your Honor. The only other person that will not be present is Millian Lopez Alvarez. She's still in the hospital.
Okay. Then we'll return to the state of Florida versus Xavier Carlisle. Good afternoon, sir. Would you please state your name and date of birth?
Xavier Carlisle, 12/10/91.
All right, Mr. Carlisle, you're here for an initial appearance on an out-of-county arrest on an out-of-county warrant from Volusia County on a failure to appear on a charge of burglary with an assault or battery. I'll appoint the Public Defender's Office provisionally to represent you for the purpose of this initial appearance. Mr. Williams, did the defense wish to be heard?
We just ask the court set a reasonable bond.
State?
We would ask that the bond remain at zero. Due to this being an out-of-county case, the state does not have enough information regarding victims involved. And also this is alleging violence, a crime of violence. So we would ask that it remain at no bond, Your Honor, and no contact with any of the victims involved.
Right. Court will stay the bond on the out-of-county warrant. Bond will be addressed by the magistrate having jurisdiction. Thank you. That concludes your initial appearance, sir. Next case, 2020 CF 319, the state of Florida versus Nara Braithwaite.
It's approaching, Your Honor.
Good afternoon. If you'd please state your name and date of birth.
Nara Braithwaite, March 8, 1996.
All right, Ms. Braithwaite, you are here for initial appearance on a warrant for violation of probation on an underlying charge, three counts of burglary of a conveyance and 1 count of battery. It's alleged you violated your probation by failing to report on November 16th of 2022. I'm advised you're seeking appointment of the public defender to represent you for the purposes of this violation of probation initial appearance, and I'll appoint the public defender's office. Court will find there is probable cause to believe you violated the conditions of your probation. Mr. Williams, the VOP warrant is a no bond warrant. Did the defense wish to be heard?
No, if Your Honor is not changing bonds based on VOP warrants, then there's no argument based on that.
All right. Court will stay the no bond status on the warrant, and conditions of release and bond will be determined by the assigned judge. Thank you. Have a good day, ma'am. The state of Florida versus Terrence Cunningham Jones. Good afternoon, sir. Please state your name and date of birth.
Terrence Cunningham Jones, 7/12/1994.
All right. thank you very much. You are here for an initial appearance on a warrant for your failure to appear for arraignment on a charge of resisting a law enforcement officer with violence on or about January 4th of 2023. You have requested appointment of the public defender, and I'll appoint the public defender's office to represent you. Mr. Williams?
Yes, Your Honor. First, we asked if the bond could be set to a round number, whether that be 2,900 or 3,000, Your Honor. And secondly, if that's not possible, can we at least have the judge who signed the warrant so you can pursue a bond motion if it's viable?
All right. Ms. Boudin, did the state wish to be heard?
Your Honor, state would ask that the bond remain as to what the judge said it, who signed on the warrant. Mr. Cunningham Jones has failed to appear twice on this case.
Court will grant the defense request to increase bond by $1. Bond is set on the warrant in the amount of $3,000.
Thank you, Your Honor.
I guess I'm not a huge fan of that practice of doing the 99 warrants because I think it's up to the surety to determine the risk of their bond. So let me go ahead and call this case 2023 CF 151, the state of Florida versus Gani Jurbayev.
Danielle Pennell on behalf of the state of Florida.
Is that the public attorney, Your Honor, or?
No, this is the potential interpreter case. Yes, Madam Clerk?
I was notified by the interpreter services that the used Beck interpreter is on a trial that's in the last 2 months, and they're not gonna be available. It's the only interpreter they have for used Beck.
Okay.
I told them I would keep in communication with her today, but they said they highly doubt they're gonna be able to get that interpreter tonight.
We're waiving reading on the charge.
Mr. Jurabayev,
Yes, sir.
can you understand English?
Yes, I understand.
Okay, my understanding is that you gave an interview with law enforcement at some point, is that right? I'm not going to ask you, you've nodded affirmatively, I'm not going to ask you the contents of that interview, but I am going to ask you, was that interview conducted in English?
Yeah, I understand you. I understand.
All right. Ms. Pinal, I'm satisfied that for today's limited proceeding, we can proceed without an Uzbek interpreter, understanding that one is not available. Do you agree?
Your Honor, with the defendant's affirmation that he understands English, I agree with the court. Although the defendant hasn't been sworn, I don't believe.
Were they all sworn at the beginning?
No, Your Honor. As far as if you want, I can swear him in now.
Mr. Jurbayev, you've sought appointment of the public defender's office, is that right?
Yes.
All right, you can have him sworn. Speak slowly, please.
Sir, raise your right hand. Can you hear me?
No.
He said
Ra-
no.
Raise your right hand. Can you hear me now?
Yes.
Do you solemnly swear or affirm that the testimony that you're about to enter in this case to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
And again, you do understand English?
Yes, I understand.
You've understood everything I've said up to this point?
Uh-huh.
And you're seeking appointment of the public defender's office, so I'll appoint the public defender's office to represent you for the purposes of this initial appearance. Did the defense wish to be heard with respect to probable cause?
Yes, Your Honor, the argument is based around the intent of the alleged act. Specifically, there's conflicting statements in terms of the distance between. There is one witness interviewed by police that said it was 6 feet, and in the interview, it was repeated that it's between 12 to 6 feet. And taking that into account with the initial aggressor being the alleged victim in this conflict, and Mr. Gani's reaction being to that initial aggression by the alleged victim, we're arguing that he was acting in self-defense and didn't have the requisite intent for premeditation.
Ms. Pinal?
Your Honor, there was an arrest warrant obtained for the defendant's arrest for first-degree murder in this case. Probable cause was previously determined by a judge. Also, there is ample probable cause listed within the affidavit for arrest warrant. The defendant made numerous admissions that he is the person that shot the victim. There is surveillance video that shows the altercation between the victim and the defendant. At the time that the defendant shot and killed the victim was retreating from the defendant. The state would ask, based upon the charges and it being a capital offense, that the defendant remain on no bond.
If it may be heard in response to that, Your Honor.
Yes.
So the reference opposing counsel made to the walking away was listed in a video the officer narrated within his report, but it's important to note that the officer himself didn't identify any of the males. He said there was around 3 or 4 males. However, he said specifically presumed one of them to be the alleged victim throughout that encounter, and he never labeled the remaining males in that video. So that's too vague to say that it was specifically Mr. Ganny that was the one, or to lend any credibility towards that video at this time.
I have reviewed the affidavit for arrest warrant, and it alleges specifically that a male identified as Bekzad appears to retreat with the other males following. Accordingly, the court finds that there is probable cause for the offense with which the defendant is charged. Given the nature of the offense being a capital offense, the court will stay the no bond on the warrant pending a determination under Arthur versus State. Anything else, Ms. Punal?
No, Your Honor, thank you so much.
Thank you. Mr. Williams, that's it on this case. Thank you, Mr. Jerbayev. State of Florida versus Jacon Fairley, 2022 CF 2202 and 2022 MM 1784.
Jaquan Fairley, 11/24/1994.
All right, thank you very much, Mr. Fairley. You are here for initial appearance on charges arising out of 2022 CF 2202, for which your public defender, who I am now appointing, has waived reading of those charges. Does the defense wish to be heard as to probable cause?
Not specifically probable cause, Your Honor. I just want to bring to the court's attention, I believe earlier this morning, the state filed a motion for pretrial detention. And the only thing the defense would like to say in regards is that the record could reflect that the court, if they find probable cause, that'll be based on proof, evident presumption rate based on the 4 corners, and then to delay the side of probable cause for that Arthur hearing in front of.
Counsel, is there any way you can get a little closer to the microphone?
Yes.
Or maybe direct it towards you a little more? I don't know, I'm having a hard time hearing you.
Okay. So the defense does not have a direct argument towards probable cause because the state has filed a motion for pretrial detention on this case earlier this morning. We're not sure which judge it will be heard in front of, but we would ask the court to allow that argument to be heard at the hearing. But if the court will be finding probable cause today, we just ask that the record could reflect it's based on proof, evident, presumption grade, based on the 4 corners.
Well, I'm permitted to detain the defendant pending a determination as to whether or not the proof is evident, presumption great. Are you seeking to have that adversarial determination now?
No, Your Honor.
Okay. Are you seeking any relief other than just having the defendant held no bond pending a determination of the motion for pretrial detention, Ms. Boudin? You've handed me your motion. What do you want to do about it?
That's correct, Your Honor. We're asking the court to find the motion legally sufficient and set the hearing before, I believe it's Judge Wilson that this case is assigned to.
All right, the court will find probable cause for the offenses charged in the information. The defendant will be held without bond pending determination of the motion for pretrial detention. That motion will be determined by the assigned judge in the case. In 2022 MM 1784, Mr. Fairley, you are here on arrest on a warrant for failure to appear on August 25th of 2022 for arraignment on a charge of resisting an officer without violence. Bond as to that warrant was set at the amount of $2,000. Court will stay the bond as to the warrant in that case.
Judge, may I?
Yes.
The state is asking for the court to revoke bond on the 22 MM 1784 because while he was out on bond, he picked up the new case, which is 22 CF 2202.
Mr. Williams, did you wish to be heard as to the state's request on that case?
We ask that the bond be maintained until the Arthur hearing on the capital case, Your Honor.
I'll grant that request. As to whether or not revocation of bond is appropriate in 2022 MM 1784, that determination will be made by the assigned judge at the hearing on the state's motion for pretrial detention. That concludes your initial appearance, sir. Thank you.
Your Honor, did you include the conditions of the warrant? I'm sorry.
I'm sorry?
Did he include the conditions of the warrant for that first case?
I believe there's already conditions on the warrant, Your Honor. Conditions are bond, none with conditions of no contact with the victim and no return to the incident locations and no possession of any firearms.
Continue those conditions pending the assigned judge's determination of the motion for pretrial detention. The next case is the State of Florida versus Kyle Hernandez, 2021 CF 1985.
Morning, Your Honor.
Good afternoon. Could you please state your name and date of birth?
Kyle Hernandez, June 27th, 1988.
All right, thank you very much, Mr. Hernandez. You were arrested on a violation of probation warrant alleging you violated your probation related to an underlying charge of domestic violence, battery by strangulation, and false imprisonment by failing to report to probation on or about December 14th of 2022. You've sought appointment of the public defender for the purposes of today's proceedings, and I'll appoint the public defender. Mr. Williams, did the defense wish to be heard?
Only if Your Honor is not inclined to change the BOP warrant, there's no argument if Your Honor is not inclined.
All right. Court finds there's probable cause to believe the defendant violated the conditions of his probation. Bond on the VOP warrant is set at none, and the court will stay the bond at none on the VOP warrant. Bond may be addressed by the judge assigned to the case. The next case is the State of Florida versus James Holcomb, 2020 CF 3583. Good afternoon, sir. If you please state your name and date of birth.
James Holcomb, November 4th, 1990.
Mr. Holcomb, you've indicated that you intend to retain private counsel, is that right?
No, sir, I previously certified conflict of interest with the Public Defender's Office and was appointed Sergio Cruz, law office of Sergio Cruz.
He's not present there with you, is he?
No, sir.
All right. Was the nature of that conflict related to this case?
Yes, sir, it was under the same case number.
All right, then, Mr. Holcomb, you were arrested on a warrant for violation of probation, alleging that you violated the conditions of your probation on an underlying offense of failure to report by failing to submit to electronic monitoring. The court will find that there is probable cause, and a probable cause determination has been made by the issuing magistrate that you violated the conditions of your probation. You have an offense which qualifies you as a violent felony offender of special concern, and as a result, Florida law prohibits me from granting you a bond with respect to this violation of probation. Ms. Boudin, did the state wish to be heard in any respect?
One moment, Your Honor. I'm sorry, I cannot find the packet for the new case. Your Honor, just one moment. Nothing from the state, Your Honor.
By virtue of the defendant's status, the court will stay the no bond warrant on the violation of probation.
May I ask the offense date on that violation of probation?
It is for the violation.
Yes, sir.
The violation is premised on a failure to submit to electronic monitoring as a result of a bracelet gone alert on January 1st of 2023.
Yes, sir, thank you.
All right, thank you. Have a good day. Next case is the State of Florida versus Alexander Jean Marie.
Your Honor, there's someone here for that.
Thank you. 2023 CF 0085. Sir, would you please state your name and date of birth?
Alexander Jean-Marie, 110784.
All right, thank you, Mr. Jean-Marie. You were arrested on a warrant for aggravated battery. You've sought appointment of the public defender, and I'll appoint the public defender's office for the purposes of this initial appearance. Mr. Williams, did the defense wish to be heard as to probable cause?
Not at this time, Your Honor.
Court has reviewed the charging affidavit and finds that there is probable cause to believe the defendant committed the offense with which he is charged. Does the defense wish to be heard as to bond?
It's possible, Your Honor, PTR will bond. If he doesn't qualify for PTR, at least a bond, straight bond.
He qualifies for PTR with bond. Bond is presently set on the sole charge in the amount of $5,000. I understand that there is an alleged victim present, ma'am?
Your Honor, the state would like to be heard on bond, regarding bond. I'm not sure if the victim wants to testify. She has relayed to me her wishes and to inform them.
Okay, go ahead.
Your Honor, state would be asking for bond to remain at zero on this case, based on the injuries that are present, that are in the report. The injuries are extensive. There was a child present. There is a history of violence here between the victim and the defendant. The victim wishes for there to be no contact and no return. She is in fear, Your Honor, and the state would ask that the court have bond remain at zero with those conditions.
Did she wish to be heard or not? She doesn't have to.
No, Your Honor.
Mr. Williams, what says the defense?
Your Honor, you'll be minimal to no contact order. He has just explained to me that he has no intention to go back there, and he lives 3 hours away from her, so any chance of contact that's not intentional is extremely low.
Will PTR require him to have an address here?
No, he does not have to have an address to be placed on pretrial release.
Okay. All right, the court will set bond in the amount of $5,000 as to the sole charge of aggravated battery. Non-monetary conditions of release will require that the defendant have no contact directly or indirectly with the alleged victim or any member of her family, and no return to the scene of the offense. Additionally, while on release, the defendant shall not possess weapons, firearms, or ammunition. Are there any other non-monetary conditions of release that the state would seek?
No, Your Honor.
Anything else, Mr. Williams?
No, Your Honor.
Mr. Jean-Marie, that concludes your initial appearance. Thank you. Next case, the State of Florida versus Brian Meyer, 2022 CF 3062. Sir, would you please state your name and date of birth?
Brian Meyer, 06161980.
All right, thank you, Mr. Meyer. This is your initial appearance on a warrant for 3 charges of failure to report. You've sought appointment of the public defender, so I'll appoint the public defender's office to represent you for today's hearing. I've reviewed, any argument as to probable cause, Mr. Williams?
No argument as to probable cause.
Probable cause has been determined based on the arrest warrant, and this court further finds probable cause as to each of the offenses alleged in this case. Is that a Wookiee? So, Ms. Boudin, bond was set on the warrant in the amount of $3,000. Has defendant previously been convicted of an offense that would qualify him for designation as a violent felony offender of special concern? One would imagine so.
Checking, Your Honor.
You know, that's neither here nor there. I was thinking of a violation of probation for some reason.
Yes, Your Honor.
Is the state seeking any relief with respect to previously set bond in the amount of $3,000?
Your Honor, we would ask that those bonds be raised, based on, based on these charges, there's indication that he may be a violent felony offender. So, if the court would like me to find that information, I can, Your Honor, but I think it's evident in the charges that are alleged here that he is a violent felony offender and therefore wouldn't be entitled to bond.
That's on a violation of probation. I led you down the wrong road. Mr. Williams, did you wish to be heard as to the previously set bond in the amount of $3,000?
Yes, Your Honor, we're actually asking to lower it. Mr. Meyer is transient and $3,000 is outside of his means to pay for. And since
Oh, I understand, Judge. Sorry, I was also thinking it was a VOP. So state has no objection if the court is inclined to have the bond remain at 3,000, Your Honor, but we would still ask for it to be raised based on the charges.
All right, the defense request to reduce bond will be granted as follows. As to count one, bond is stayed at $1,000. As to count two, bond is reduced to $250. And as to count three, bond is reduced to $250. Conditions of the defendant's release are that he report as required by law and within 24 hours of the date of his release from custody. That concludes the initial appearance in this case. Thank you.
Your Honor, can you repeat counsel for me, please?
250.
First one is state. First one is state. One is state.
Next case is the State of Florida versus Marcel Nelson. Case number 2022 MM1930. Sir, would you please state your name and date of birth?
Marcel Lavelle Nelson, 7/12/80.
All right, thank you very much, Mr. Nelson. You're here for an initial appearance this morning on a warrant alleging you violated your probation on an underlying charge of domestic violence battery and resisting a law enforcement without violence by failing to report to probation as requested by probation on November 18th and November 30th, failing to pay court costs and costs of supervision, and failing to complete mental health and substance abuse evaluation and treatment as ordered in the order of your probation. You've sought appointment of the public defender to represent you here today, and I will appoint the public defender's office.
Your Honor. Please.
Mr. Williams? Yes, of course. All right, the court has found probable cause to believe you violated your probation in the manner alleged, and this court further makes that finding. Bond on the warrant was set in the amount of $0, and I guess, Mr. Wilson, did you wish to be heard?
I guess for the best advice of my lawyer, my public defender here, or whatever he says is not advised, but I do want to say that my intention was to pay everything, but in the means of doing, I have all the circumstances that I did as far as, you know, Social Security, stuff like that, in order to get the stuff I need in order to pay the fines and court fees. But now that I have stuff that I need, I have a little bit more support in order to pay that. And that's what I was on my way to doing as far as a stable place to stay and stuff like that. So all I'm saying is I was trying to ask them about an OR so I can start paying these court costs and fines. You understand what I'm saying, Your Honor? I mean, in order, because everything was going wrong for me, I didn't have all the information, I just now get my food stamps in order for me to get my phone. So now I have my phone, I have, you know, communication with everything else.
All right, good. Well, that's all stuff that points favorably to your being able to resolve this violation of probation, but you're going to need to resolve it in front of the judge that is assigned to your case. For now, the no bond is stayed on the warrant and can be addressed before Judge Epperson. Thank you. Have a good day.
Your Honor, and he has a BOP arraignment on the 26th.
Okay. That'll remain set. Next case is 2023 CF86, the State of Florida versus Tony Sykes. All right. Good afternoon, sir. Would you please state your name and date of birth?
Tony Sykes, 2/12/59.
All right, thank you, Mr. Sykes. You're here for your initial appearance this morning on certain charges. The Public Defender's Office has waived reading of those charges on your behalf, and the Public Defender is appointed as your lawyer on this case. Does the defense wish to be heard with respect to probable cause?
Not a probable cause, Your Honor.
All right. Probable cause has been determined to exist, as do the charged offenses, and the court continues and makes that finding itself. Does the state wish to be heard as to bond?
Your Honor, state would ask the bond remain at 0 based on the charges alleged here, Your Honor. There was a positive IDing Mr. Sykes as the defendant in this case, and there were serious injuries involved here. I believe the state is asking for if any bond conditions is being requested by defense or reduction in bond to be heard in front of the trial judge, so that the state has the opportunity to have the victims and all parties present, Your Honor. And if the court is inclined to give bond in this case, Your Honor, a state would ask for no contact, no return to the scene. I believe it was on the highway. So no contact, Your Honor, no weapons or firearms.
Mr. Williams, did you wish to be heard as to bond?
Yes, Your Honor, we would ask that you set a reasonable bond for the charges. But there is no objection to the no contact order. That's what's required for the specific charges. We would ask that a bond is set.
I have reviewed the application and affidavit for arrest warrant, and given the nature of the offenses and the weight of the evidence against the defendant, the court finds it appropriate to hold the defendant without bond pending a determination as to whether or not he's subject to further pretrial detention on appropriate motion by the state. The court will stay no bond on the warrant. That concludes the initial appearance in this case.
Any conditions, Your Honor?
I mean, he's not being released, so no contact, no return. 2023 MM137, the State of Florida versus Odalis Diaz.
Your Honor, for the court's information, the victim is present.
All right. Good afternoon, ma'am. Would you please state your name and date of birth?
Odalis Diaz, September 23rd, 1968.
All right, thank you. Ms. Diaz, you are here for an initial appearance after an arrest on a charge of misdemeanor battery. I'm appointing the public defender to represent you for today's hearing. Public defender is appointed. Did the defense wish to be heard as the probable cause?
Not a probable cause, Your Honor.
All right, court finds there is probable cause to believe the defendant committed the offense with which she is charged. Bond has not been set. Would the state wish to be heard?
Yes, Your Honor. The state would ask for no bond due to how recent the incident is, Your Honor. The state is asking for time to reach out to the victim and understand what happened here. This is an act of violence, and it was captured on video in which the officer saw that the defendant did commit the battery against the victim. If the court is inclined to give a bond, state would ask for a high bond with conditions of no contact and no return, Your Honor.
Did Mr. Diaz wish to provide testimony?
Yes, Your Honor.
All right, sir, if you could come to the podium, please. If you would face the clerk, raise your right hand to be sworn.
Do you solemnly swear or affirm?
It's the other one.
Oh, this one.
Everybody does that.
Do you solemnly swear or affirm to tell the truth, the whole truth, nothing but the truth, so help you God?
I do.
All right, sir, Mr. Diaz, you have a right to be heard under Marcy's Law, and the court will take that into consideration in taking action on the defendant's monetary bond and non-monetary conditions of release. What would you like me to know?
I just wanted to express that, this hadn't happened before. It's the first situation. My wife is a very good person, a very good mother. Unfortunately, because of circumstances, financial and otherwise, we've been going through a lot of stress. We also have a child at home that she has to care for, and he's already over 18. So I think it's a combination of things that occurred, and everybody has a breaking point, and I think that was her breaking point, but I don't want to file any charges against her.
All right.
I'm sorry, Your Honor, we couldn't hear the last part of what you said.
Can you repeat it a little louder?
I do not want to file any charges against her.
All right. Ms. Bourdain, did you wish to be heard any further?
Nothing from the state, Your Honor.
Mr. Williams,
Yes, Your Honor.
go ahead.
Mr. Diaz, are you scared of everyone?
No, sir.
If the court were allowed her to be around you, would you be scared to call the police if you were afraid for your life?
No.
Would you prefer to be around your wife if she was released from jail?
Yes.
And currently, whose name, do you guys currently live at the same residence?
Yes, we do.
Are you guys equal owners of the residence, or is only one person's name on the tab?
On the title, it's in her name.
No further questions, Your Honor.
All right. Based on what Mr. Diaz has shared with me, there was another person present, Mr. Odalis Diaz. I don't think he's an alleged victim in the case, is he?
No, Your Honor.
All right, then simply observing. Based on what Mr. Diaz has shared, the court will release the defendant on her own recognizance with non-monetary conditions that she have no hostile contact with the alleged victim in the case. Mr. Diaz, Mr. Williams, you'll explain to your client that in the event there is hostile contact, that might provide a basis for the court to revoke the defendant's release in the case.
Yes, sir.
All right, thank you very much, sir.
I'm sorry, you said there was a bond amount or?
No, released on own recognizance.
Okay.
State of Florida versus Angel Gonzalez Ruiz, 2023 CT 199 and 2023 MM 139. Good afternoon, sir.
Good afternoon, Your Honor.
You've sought appointment of the public defender in this case, so I will appoint the public defender for today's proceedings. You're here for an initial appearance after an arrest in 2023 MM 139 for providing false name or identification to a law enforcement officer, which is a first-degree misdemeanor, and in 2023 CT 199 for driving with a suspended license with knowledge of that suspension. Mr. Williams, does the defense wish to be heard as to probable cause?
Not probable cause, Your Honor.
Right. Court will find there's probable cause for each of the alleged offenses as to each of the cases. Bond has been set in the amount of $500 as to 2023 CT 199. And also in $500, the amount of $500 with respect to 2023 MM 139. Did the state or defense wish to be heard as to bond?
Yes, sir.
All right.
Well, that said, he released on his own recognizance. He admitted in that police report, you'll see that the police said he contacted him and just talked with him about the case, and there's nothing violent in these charges. And if it's history, it's clean as he's conveyed to me, then we
What did you say about history?
If he has some prior history that would indicate his unwillingness to show up to court when instructed to, who asks that he be released on his own recognizance.
He is on bond in 2022 CF 7882.
Okay, then we will ask that bond be stayed.
Ms. Boudin?
Yes, Your Honor. State would ask that bond conditions remain at 500 on both of these cases, Your Honor. On the Dwellis, state would ask conditions be that he's not to be driving, and on 2022 CF 7782, state would ask that his, I believe that's the court case number, Your Honor, right?
That's right.
State would ask that bond be revoked based on the defendant picking up the new charges.
Your Honor, and it's also an Orange County case.
Mr. Williams, did you wish to be heard any further as to whether or not the court should revoke the defendant's bond and release in 2022 CF 7882 as a result of there being probable cause to believe he committed these two new criminal offenses?
Just that, since these are traffic offenses, while the criminal traffic, the last the court to take into account that there are traffic offenses that won't prevent him from showing up to court if called upon by the court there.
All right, in 2023 MM139, the court will stay the bond in that case in the amount of $500. In 2023 CT199, court will stay the bond in the amount of $500. And as a non-monetary condition of the defendant's release in that case, he shall not drive without a valid driver's license. The court will decline at this time to revoke the defendant's bond in 2022 CF 7882, given the nature of the new offenses being criminal traffic offense and a misdemeanor. The assigned judge can consider whether or not to revoke bond.
No action, Judge?
No action on that. That concludes the initial appearance. Thank you. The State of Florida versus Milia Ned Lopez Alvarez, 2023 CF 169 and 2021 CF 3285. Did you say that was medical?
Yes, Your Honor.
What is the defendant's status? All right. Initial appearance to be reset within 24 hours of the defendant's release from the hospital. MM141, the State of Florida versus Jason Patridge.
He's in the back, Your Honor. He's the first.
Thank you. Good afternoon. Would you please state your name and date of birth?
My name is Jason Partridge, 1980 for April 1st.
All right, thank you, Mr. Partridge. You are here for an initial appearance after your arrest on the charge of misdemeanor battery. You've sought appointment of the public defender to represent you, so I will appoint the public defender to represent you provisionally pending a determination of indigence. Mr. Williams, did the defense wish to be heard as to probable cause?
Never probable cause.
Court will find there is probable cause to believe the defendant committed the offenses with which he is charged. Did the state wish to be heard as to bond?
Your Honor, state would ask that bond remain at 0 until there's more information regarding contact with the victim due to how recent the events were. If the court is inclined to give bond, they would ask that conditions be no contact and no return. I believe they're staying at the Roadway Motel, or no contact and no return to the Roadway Inn at 4624 West 192. And state would ask that the court give a high bond.
Mr. Williams, what says the defense?
We would ask the court to give him the right PTR or an alternative PTR with bond. If his history does not rely on violent or any failures to appear, we would ask that the court take into consideration this is the only offense he's up for, and if that pretrial release condition will prevent any contact with that victim, he's amenable to it.
Your Honor, pretrial release spoke with the victim this morning, and she advised she does not want contact, and she does not want him to return.
All right. Court will, you've said that he doesn't qualify for medical reasons?
Correct.
Can you share them on the record or not?
Due to mental health concerns.
Okay. Court will set bond in the amount of $500 as to the sole charge. Conditions of the defendant's release are that he have no contact with the alleged victim, Catherine Kleckler, no return to the scene of the offense at the Roadway Inn located at 4624 West US 192. However, to the extent the defendant has any personal effects located at the scene of the offense, he will be permitted a one-time return accompanied by law enforcement in order to obtain those personal effects.
Your Honor, I apologize. I forgot one condition of bond, no weapons or firearms.
While on release, the defendant shall not possess weapons, firearms, or ammunition. Anything else, Mr. Williams?
That's it, Your Honor.
All right, thank you, Mr. Partridge. State of Florida versus Charlene Salazar, 2023 MM142. Good afternoon, ma'am. Could you please state your name and date of birth for the record?
Charlie Salazar, 549.
All right, thank you, Ms. Salazar. You were here for an initial appearance after your arrest for simple assault. You sought appointment of the public defender for today's proceedings, and I'll appoint the public defender to represent you. Mr. Williams, does the defense wish to be heard as a probable cause?
No, Your Honor, not a problem.
Court finds probable cause to believe the defendant committed the offense with which she is charged. Does the state wish to be heard as a bond?
Yes, Your Honor. The state would ask that bond remain at zero based on how recent the events are. This is alleging violence, and the officer did see evidence to corroborate the victim's story. In this case, the victim is a minor. The state would ask if the court is inclined to give a bond, to give a high bond, no contact with the victim, no return to the victim's residence, which I believe is where the incident took place. I'll get the address for Your Honor, and no weapons and no firearms. I believe it's 2119 Jessica Drive in Kissimmee.
Mr. Williams, can you inquire of your client as to where the minor child presently resides, if she knows?
She says the child was with her at that.
Your Honor, I do believe that the minor's grandmother also lives there. If the court is inclined to ask the defendant if the minor is staying with his grandmother.
Mr. Williams, can you inquire of your client as to whether or not the grandmother resides there as well?
Yes, Your Honor. She says her mother resides as well.
All right. And there's no one in the courtroom on this case?
Not that the state is aware of, Your Honor.
Has PTR had any contact with the grandmother?
No, we haven't.
No?
Due to her not being listed as a
Sure.
victim.
All right, the court will grant bond in the amount of $500 with respect to the sole charge. The conditions of the defendant's release are that she have no contact with the alleged victim, the minor child, and no return to the scene of the offense at 2119 Jessica Drive. The defendant will be required to maintain a separate residence from the minor child and her mother until such time as this case is resolved. Or the defense seeks a motion or seeks modification of the conditions of pretrial release. I would imagine she needs to return one time?
Yes, sir.
Right. Defendant will be permitted a one-time return to 2119 Jessica Drive, accompanied by law enforcement in order to obtain her personal belongings. That concludes the initial appearance. Thank you, Ms. Salazar.
Your Honor, you gave her bond with PTR?
No PTR. (2022) CF 2041, the state of Florida versus Heather Hudson. Good afternoon. Would you please state your name and date of birth? All right. Ms. Hudson is here for an initial appearance after execution of a warrant for failure to appear for pretrial conference on an underlying charge of possession of fentanyl on or about January 11th of 2023. You've sought, or the court will appoint the public defender's office for you for the purposes of this hearing, Ms. Hudson. Bond is set in the amount of $5,000 on the warrant. Does the defense wish to be heard as to bond?
If Your Honor's not able to change the previous judge's bond, there's no argument, but if you are, you would ask that it be lowered, potentially with the conditions and underlying was a drug offense. If Your Honor's applying for no drugs or alcohol, that's a possibility as well.
Court will stay the bond in the amount of $5,000 and add conditions that the defendant, while on release, shall not possess or consume drugs, alcohol, or controlled substances without a prescription. That's it on the case. Thank you, ma'am. 2022, State of Florida versus Kevin John Brarman. Afternoon, sir. Would you please state your name and date of birth?
Kevin John Brown, 72977.
All right, thank you, sir. You're here for an initial appearance this morning after execution of a warrant out of Volusia County for your failure to appear in court on an underlying charge of felony battery and resisting a law enforcement officer without violence. I'll appoint the public defender's office provisionally for the purposes of today's hearing. Mr. Williams, did you wish to be heard? All right, the warrant out of Volusia County is no bond. The court will stay the no bond status of that warrant, and bond can be addressed by the issuing magistrate in Volusia County. Thank you, sir. So are McFarland, Page, and Burgos all present?
I'm sorry?
Are the folks from yesterday there?
Yes.
Okay.